Good morning, everyone, and welcome to our 2022 Labor and Employment Annual Webinar. I'm Tricia Riley, the chair of Murtha Cullina's Labor and Employment Group. We're very excited to have a large group of clients with us today for this very interesting, we hope, webinar about updates that have happened through 2022. As those of you who've received the invitation know, we have a very robust agenda, and you can log in and out as you wish in order to join just certain sections that you might be interested in hearing. We ask that you hold questions till the end. There's a Q&A function and a chat function, and any questions, if we have time, we'll be happy to address questions when there is time. Some of the webinars, some of the sections may go over, but some may have time for sections, for questions after their section. As you know, Murtha Cullina has a blog post that we invite all of you to subscribe to, and we hope that we will be putting a lot of blog posts out after the webinar as well. All attendees are in listen-only mode, and we cannot see or hear you, but if there's any issues, please notify us in the chat function. And again, some of our sections actually encourage interactivity. We have questions that we want participation in, and others, if there's time at the end, we encourage questions. And with that, we are ready to get going, and we look forward to your participation today, and we hope that you enjoy your day. Thanks very much.
So good morning, all. I'm Sal Gangemi, and I'm going to be speaking on this panel together with Lori Letty and Jamie Radke, and we are going to be talking about legislative updates in Connecticut, Massachusetts, and New York. I wish I could tell you we had a lot to report, but the legislatures in each of the states were not particularly active this term, but they've come up with some interesting legislation that we think you should know about, because I think these reflect trends for the future and what we can expect in the next couple of years. So something that years ago you might have thought you would never see or would never happen. I think you're going to see now, and you're going to be surprised. I know I've been very surprised. So without further ado, I'm going to pass the torch over to Lori Letty, who will razzle and dazzle you with Connecticut legislative updates.
Well, now after that introduction, Sal, I'm concerned that I'm going to let everyone down, because it's been a pretty quiet year in Connecticut. But we're going to get through a couple of key pieces of legislation, and then what I've done this year is we've been monitoring some legislation that has kind of been percolating over the years, and it's gaining momentum. So we're also going to talk about that today. So if you could switch to the next slide, Eden. So this is the overview of what we're going to be talking about. First, as everybody's probably familiar with, who's practices in Connecticut or works in Connecticut, we have the Connecticut Fair Employment Practices Act, what we call SFEPA, and every year we get some sort of new definition or some sort of modification to that statute. This is a typical year. We do have some changes. There's also some additions to the voting time off rules. We've been monitoring the annual increases in minimum wage, which started several years ago, and now we're continuing. There's also there's a new legislation about the prevailing wage penalties for those of you here who deal with public contracts. And then there are the two major pieces of legislation are free speech protections that went into place, and I'm going to be passing on that one so that we have a full discussion on that in a separate segment. And then there's the pay transparency statute. Again, that's going to be something that we're going to be addressing separately in a full section as we go forward. So if you could switch to the next one. We'll start with the changes to SFEPA for 2022. As I stated, SVEPA stands for the Connecticut Fair Employment Practices Act. And this is our employment discrimination statute that addresses the types of protected classes, protected employees, the types of conduct that are considered discriminatory or harassment. And this year, the modifications, one of them is actually pretty significant. The definition of employer, as you know, the statute applies only to employers. It's actually been modified this year. It had previously been an employer is any organization or entity that employs 3 or more employees. They've now modified that to reduce it to 1 or more employee. So basically, SVEPA now applies to every employer. So all you have to do is have 1 individual employee, and now you're governed by SVEPA. So that is something for small businesses in particular to pay attention to. And keep in mind that there's this issue about whether independent contractors fall within the protections of SVEPA, and that's a kind of a minefield. So if you're classifying employees as independent contractors in order to avoid fitting within the definition of SVEPA, that is a minefield. There are problems with doing that. So we recommend that you pay attention to the number of bodies rather than how you're classifying the individuals. The definition of employee has also been expanded to include anybody who's an elected or appointed official of a municipality, board, commission, council, or other governmental body. So if any folks on the webinar today are involved in government in any respect, now the definition of employee now applies to individuals that you employ. So that's actually a relatively big change if you're a government employer. And then the last change is protected status. This year, they've added victims of domestic violence. So there are particular protections now in place for victims of domestic violence. There are also accommodations that have been added to the statute, so that if you have an employee who's a victim of domestic violence, you've got to pay attention to what some of the protections are that would apply to that person. You can switch this slide for me, Eden. Well, and now this is relating to this update to the existing statute is for voting time that's allowed now under Connecticut general statutes. The original law passed in 2021, and it was relatively expansive, and it talked about any state elections that are occurring between June of 2021 through June of 2024. We expect that it'll probably be expanded. But if you have employees who want to go vote in elections, they are entitled to have 2 hours of unpaid leave on election day. This year, it's been expanded to include probate court special elections. So that must have been knocked out for the original version that went into effect in 2021. The time off must be between 6 a.m. and 8 p.m., which is when the polls are open in the state of Connecticut. And in most instances, the employee is supposed to provide you with notice at least 2 working days prior to that, so that you don't have scheduling conflicts or any issues with staffing. But we just want to make sure that you're aware of the fact that they now actually have a right for the unpaid 2 hours in order to go vote in state elections. If you could move on to the next slide. The Connecticut minimum wage statute is, as I've been telling folks for the last couple of years, this went into effect in 2019, and it had step increases, a dollar per increase over several periods of time. The most recent, of course, $14 per hour went into place on July 2022, and the next hike, which is the last one under this statute, goes into effect next year on June 1, 2025, and that will take the minimum wage in the state of Connecticut up to $15. You can now, for those of you who have any kind of relationship with government contracting, there was a radical overhaul to the prevailing wage statute this year, which talks about enforcement. They're really, the state legislature is really putting some teeth behind some of the penalties that apply if you're a government contractor. And now they've increased the fines. substantially if you are caught violating the prevailing wage statute. And for those of you who don't know, what that means is in government contracts, you are obligated to pay your subcontractors and your contractors and any employees of those entities the prevailing wage for the type of work that they're doing. So if you've got any kind of construction work, you have to pay prevailing wage based on what the prevailing wage is for the specialty, or, if the plumbers get certain rates and what have you. So if you fail to pay prevailing wage now, you are potentially subject to significant fines in the state of Connecticut. The Attorney General has now also been authorized to commence civil actions against violators. What that does is individuals are no longer the only ones that can sue their employers. It gives sort of a protector role to the Attorney General's office so that the Attorney General can start those actions on behalf of employees. And it also allows the Department of Labor to debar any contractors or any employers that are repeat offenders. And what that means is if you violate over $50,000 in wages per year, the state can decide that they can suspend your ability to contract with the state for a period of time, or they can decline to allow you to contract with the state forever. They can prevent you from having any state contracts. So the penalties have gotten very, very stiff for anybody who does state contracts and government contracts and violates a prevailing wage statute. If you could switch, as I mentioned, there are two major pieces of legislation that are big enough that they get their own segment this year. That's employee free speech and pay transparency. Both of those, I'm not going to get into either of those because I don't want to steal the thunder of the folks who are coming after me. Those will be handled in separate segments later in the presentation. And that's really all of the critical statutes that were enacted or went into effect in 2022. I put this slide in, and it's actually these next two slides I put in for those of us who deal with non-competes. I thought this was actually very helpful, and I know that for those of you who've been following this for several years. You know that Massachusetts enacted, I think it's in 2018, and Jamie can correct me, but I think in 2018, right. In 2018, Massachusetts enacted a statute that severely restricted the use of non-competes by all employers, private and public, in the state of Massachusetts. And there's been a trend, particularly in what we call the blue states, in that direction. They've tossed around legislation in Connecticut for many years. This particular bill, which is HB 5249, got a lot of traction this year and got very close to making it out of committee and going to the full legislature. So it's something to keep an eye on, because my guess is that this is the focus will now turn, since they've gotten the free speech and the pay transparency statutes enacted. This is going to be the focus of some heavy lifting next year, and we're probably going to see an act that will substantially limit the scope of non-competes in the state of Connecticut going forward. The version, this particular version, it applies to any non-compete that's been entered into, and they'll give you a date. Usually it's July 1 of the middle of the year that it's enacted. So if a non-compete is either entered into, modified, or extended by that particular date, the new law will apply. So it doesn't apply retroactively unless you have an evergreen non-compete, for instance, that renews automatically every year. Then the statute would apply to something like that. So it's something to keep in mind as you start looking as you start planning for the future. Keep an eye on when your non-competes renew. It essentially prohibits non-compete agreements of any sort that do not meet very specific criteria. And if you can flip to the next screen, there's a couple of specific things. All of them will be limited to 1 year, unless you can go to 2 years if the employee, when terminated, will be paid full salary for the whole 2-year period. So that would be the requirement. So you can have a longer 2 years non-compete, but you've got to basically pay your former employee for the full 2 years if that's what you want to do. Every other one will be limited to 1 year. It applies to exempt employees. And what that means is that you can only have employees with non-competes. If I have the math correct, it would be 3 times the prevailing, the minimum wage requirements. So the salary requirements would be significant, but it's not horrendous. So if you take minimum wage, next year it'll be $15. So anybody who's making the equivalent of $45 an hour or more, those folks are, anybody below that cannot have a non-compete. It requires mandatory notices to employees of their rights to consult with an attorney. It also requires them to understand that they don't have to sign them. There's an issue about consideration for those folks who practicing or who work in Connecticut. There's shifting case law, and we don't have any Supreme Court case law on whether continuing employment is sufficient consideration to enter into a new non-compete provision or to extend a non-compete provision. So the new version, this version of the proposed legislation makes it an employer must provide separate consideration for a non-compete, and continued employment, even for at-will employees, will no longer be sufficient consideration under Connecticut law. So that's what we've got to keep an eye on. And I think that the Massachusetts statute is very similar. They allow the non-competes to exist, so long as they meet very strict criteria. And my guess is that there's probably a lot of litigation, since that's been in place since 2018, of folks doing that. And Sal, I think that we've got a similar situation in New York, where you're eyeing legislation that did not make it through in 2022.
That's right.
And I think you're probably getting the same kind of thing, that there's
Yeah, so there were 2 bills in New York, one of which I don't think would have changed much. Neither one of them passed. One got stuck in the Labor Committee, and the other one just didn't make it through this term. One of the bills provided that that non-competes couldn't be enforced if if the employee lost their job as a result of undue hardship. And so they give 2 non-exclusive examples of what would have been undue hardship, and it was something like if there was a state of emergency declared or some sort of a disaster. That statute, I'm not really sure what the point of that particular bill was, because I think if there's a disaster or we're in a state of emergency, people aren't really going to be looking for another job at that moment. The other bill was a bit more serious, and it was almost I'd like to say it was very similar to California's outright ban. I don't even talk about the Californication of New York. It involved it basically applied to all employees, not just non-exempt employees. So all employees. There was nothing in the bill that related to confidential information or proprietary information or trade secrets, which I think for any bill to have any success at becoming law, these items need to be addressed, because people are going to resist, or employers are going to resist implementing these laws if they think that their proprietary information and that their trade secrets are not necessarily going to be protected. Because let's face it, there are employees, or there are people at certain levels in a company that really do hold the keys to the secret formula. And so allowing non-competes as far as those people are concerned is a lot more legitimate, I would say, and I probably shouldn't use that word, because when we draft non-competes, they're all legitimate, but they're probably a lot more legitimate than, let's say, having the receptionist sign off on a non-compete. So I don't see those bills passing through. I think Connecticut is a lot more serious than New York is.
Yeah.
And I like Massachusetts' approach, and maybe Jamie could tell us a little bit about that, because I'll tell you, Jamie, what I like about Massachusetts approach is that, at least to me, it seems very defined in terms of, the restrictions.
Yeah, that's right, Sal. So as Lori mentioned earlier, we in Massachusetts, we passed a bill in 2018 that did restrict when non-competes can be enforced and when they're going to be considered valid and hold up if they were a challenge. And so it's a lot of the same stuff that Lori got into. If you're a non-exempt employee, somebody that works part-time, a student, just an outright ban on non-competes for those people. There was sort of some horror stories about people working in fast food that were being asked to sign non-competes that really people viewed as outrageous, and that sort of spurred this law. But this was about 10 years in the making. There had been different bills that had been proposed and really strong arguments being made on both sides. And where we find ourselves now is there are some restrictions on the time period. So it's presumptively limited to 1 year. The restricted period can extend longer, but it's going to have to be reasonable under the circumstances. Prior to the law, you'd see these up to 3 years even, sometimes being enforced, and it was a bit all over the place. The other big piece of it is that there's got to be some compensation that's given. If you're an existing employee, there has to be new compensation given if you're being asked to sign a non-compete in the middle of your employment. You've got to have some consideration for that. And then the other piece is that there's got to be consideration for the period that you're restricted from competing. And that's the big question, Sal. So Sal,
let me ask you about that, Jamie. So basically, you're paying someone to sit out, right?
That's right.
Do you have to pay them for the entire period, the restricted period?
Well, this is the big issue in Massachusetts, and everybody is wondering what's going to be considered acceptable. So the way that the law sets this up is it says if the employer pays 50% of the person's salary for the period of time that they're on the sidelines, that's presumptively going to hold up, okay? But then there's this vague language about or any other agreed compensation. So what does that mean? Nobody knows. And so you see things like maybe you agree that if the employer is going to restrict the employee at their option, then they're going to give a month of severance, and that could be agreed compensation if the employee signs it. And there's all kinds of creative things that you can do. If you said, $1 or, an extra soda every day, I'm not sure that would hold up, but really nobody knows. So we do have some guidance, but really the key piece is this compensation piece, and nobody really knows what's going to hold up there.
Got it. All right. Well, listen, I know this, we could spend a whole hour and a half talking about non-competes. So Lori kind of got me and Jamie triggered. So let's go back and talk about this. One thing I'd like to see, though, since we are on non-competes, I'd like to see, and I think we're going to see, case law that really starts to dive into or address the whole geographical restriction. Because let's face it, if there's something that we've learned from COVID, and we probably learned this before COVID, is that geography doesn't really matter anymore, at least in the way things are done today. So I'm wondering to what extent, strong reliance on geographical restrictions is going to continue going forward. So.
Yeah, and I can tell you, Sal, that we have a statute in Connecticut in place already that addresses physicians. Right. So physicians are already protected by law in the types of non-competes that you can impose on a physician. And for those folks in healthcare that are on the webinar today, you already know that they're very restrictive about the length of time. They're 1 year. The geographic range is very clearly specified. Of course, I think that practice of medicine is a little different because you can impose geographic requirements on things like that. that's a face-to-face in-person thing. You can't really do that remotely. But I agree that the remote, how to define what's reasonable in geographic scope when you've got folks working and telecommuting and working remotely, that becomes much more complicated. But the other thing that we've noticed is even with the physician statute, which is sort of the test case for Connecticut, because a lot of what we're seeing in this new bill looks familiar. It looks a lot like what we've got with the physicians' restrictions on non-competes. There will be issues about whether you can what we call blue pencil, so that if you have a non-compete that violates the statute, can a court modify it? So if it's a 2-year non-compete and that violates the 1-year requirement, can the judge just say, okay, well, let's reduce it to a 1 year to comply with the statute, but everything else remains the same? And in the physician setting, the courts have actually been striking the entire non-compete down if it violates the statute. So there is no right to blue pencil. And the new this legislation that didn't make it through this year, it specifically says there shall be no blue penciling.
Wow.
So they're not going to let you rewrite your non-competes. If they violate them, they will be unenforceable as a whole. So that's a huge change. But I think that what we're seeing here, and the point we want to make to the participants today, is that this is going to be the trend. So Massachusetts has already put it in play. You're starting to see fallout from that. How do we interpret the statute? I suspect that Connecticut is watching what's going on in Massachusetts, watching how courts are interpreting the statutes and trying to learn from the Massachusetts experience. New York is being a trailblazer, because I can't imagine legislation in New York passing that would ban all non-competes. That's just shocking to me. But it's something to be aware of. And then of course you've got the interplay of when you've got folks that live in Connecticut but work in Massachusetts or work in New York City. How is that all going to be playing out? So we're putting this on everyone's radar. We will be monitoring this closely. And as we go into the next legislative session for each of the states, if we see any additional changes or any momentum on any of these statutes, we will be posting on the blog. So by all means, folks, check in, look at our blog, and we'll keep you posted on the situation with the non-compete statutes. For that's it for me. So I'm going to turn it over to Jamie now.
All right. Thanks, everybody. Thanks, Lori. I'm Jamie Radke, and I'm one of our litigators. I practice in Boston, in Murtha's Boston office. And in the employment context, I defend retaliation and harassment claims, wage and hour litigation, and I do some non-compete work as well, as we were just discussing. So I'm going to be giving the Massachusetts legislative update. Just like Connecticut, we don't have a lot of activity this year, no major legislation that's going to be going into effect, but we do have some important updates that I wanted to go through with you. So this is a quick overview here. We've been increasing the minimum wage steadily over the last few years and phasing out the Sunday and holiday premium pay. So I'll get into that a bit. We're going to talk about some changes to the paid family and medical leave law that went into effect a few years ago. We're then going to get into the Crown Act. This is a new law that went into effect that protects against discrimination for natural and protective hairstyles. So we'll talk about what that means and how that's going to impact all of you. And then lastly, I'm going to talk about some guidance that we got from the Supreme Judicial Court on the Massachusetts Wage Act. All right, so first topic, minimum wage. Starting January 1st, the minimum wage is going to increase in Massachusetts from $14.25 to $15. So this is something that's been happening over the last few years. In 2018, you may recall Massachusetts passed what we call the grand bargain legislation, okay? And this addressed a number of areas of employment law, the minimum wage, the Sunday pay that I'll get to in a second. It established the paid family and medical leave program that's been in place for the last few years. So this is a big piece of legislation. And at the time, there was a big discussion happening in Massachusetts, but also, around the country about the minimum wage, and really people were pushing to see that increased. And so Massachusetts was somewhat out front on that, and the minimum wage that was in effect at the time in 2018 was $11, and it went up about 75 cents or so each year over 5 years to $15. So starting the first of the year, we're going to be at $15, and that's the last increase that we'll see for a while here. That was the step by step. This is the end, unless there's a change in the law going forward. The other piece of it is that tipped employees, the minimum wage is going to be increasing to $6.75. It's currently $6.15 for tipped employees in Massachusetts. Something to keep in mind there is that tipped employees need to make the full $15 minimum wage for each shift. So if they're being paid the $6.75 in 2023, hourly wages, and then you add in their tips for that shift, if that does not equal the minimum wage for the hours that they worked, the employer's got to make up the difference. And that's looked at on a shift by shift basis. You can't offset if a server at a restaurant, for example, has a good Friday night and then not such a good Saturday night, and they don't make the minimum wage. You can't combine those. The employer has to make up the difference on the night where they weren't paid the minimum wage. Okay, next slide, please. So the other part of this is that this was part of the so-called bargain, that if we're going to be increasing the minimum wage, we'll give employers a bit of a break by phasing out the law that we have in Massachusetts that requires pay of 1.5 times the person's regular rate for Sunday work and for hours worked on certain holidays. So traditionally, if you work on Sunday, you're getting time and a half. That has been phased down over the last few years since 2018. It went to 1.4, 1.3. In 2022, it was 1.1, and now we're going to be just at, starting in first of the year, no premium pay for Sunday work and for certain holidays. And this is where it gets a little bit tricky. So there will be no premium for Memorial Day, Independence Day, Juneteenth, Independence Day, and Labor Day. There are a few holidays, New Year's Day, Columbus Day, Veterans Day, that are not affected by this. You still got to pay time and a half for those holidays. Nothing that I've read is really clear on why there's a difference there. I've read some people think that was actually just an oversight. So just be aware that there is a difference with certain holidays, that if you're going to have folks working in retail on those holidays, they still need to get time and a half. But for the most part, Sundays and then the specific holidays I've mentioned here, premium pay is no longer in place in Massachusetts. We can go on to the next one. Okay. This is dealing with the paid family and medical leave statute that we have here in Massachusetts. We've been dealing with this for the last few years, also part of the grand bargain legislation. And so you may recall that this is a law that allows people to take leave for certain covered reasons, for both medical reasons and family reasons. I'm not going to do a deep dive on exactly who's covered and what those reasons are. We covered that a couple of years ago, and it's been in place here for a couple of years. So I'm not going to hit that as part of this update. But what you do need to know is that the contribution rates are changing. So this program, you may recall, is funded through a payroll tax, and it comes from both the employees, and then for larger employees, the employer also has a contribution that they're required to make. So that contribution this year is going to decrease a little bit. So for employers who have more than 25 employees, the larger employers, the total contribution is going to go down from 0.63% of eligible to 0.63% of eligible wages. And then that gets divided further into two buckets. There's the medical contribution and then the family contribution. Okay. And so on the medical side, the contribution amount is going to be 0.53% of eligible wages, and the larger employers have to cover 60% of that. Okay. The employee makes up the other 40%. And then on the family side, the contribution rate is going to be 0.11%, and that's all done through a deduction from the employee. For smaller employers, those with under 25 employees, the rate is going to decrease this year to 0.318%. And you can see how that breaks out between the medical and the family. The other big change here is that the maximum weekly benefit is going to increase. So it's now going to be $1,129.82. So the takeaways here are that, make sure that your payroll department or your outside payroll company is aware of the change, because you want to make sure that you are getting those deductions right. And it's the employer's obligation to withhold those amounts and to contribute where they have to contribute, and then to remit those amounts to the state as part of this program. So you want to make sure that you're aware of the change to the rates, that you're withholding the right amounts. Okay. Couple of other important points is that you do have to notify your employees 30 days in advance of a change in the rates. And so we're at December 9th here, and these rates go into effect on the 1st of the year. So you were supposed to notify your employees by December 2nd. I suspect there's a lot of employers out there that maybe weren't aware of this, have not done this. So you want to get on that. The Department of Family and Medical Leave has a website where they have rate sheets and they have form notices that you can use to send to your employees of the change. And that can be done electronically. So you can send that by email to your employees. For existing employees, you do not need them to acknowledge their receipt. Okay, so you can send this change by electronically, and you don't need an acknowledgement back. For new employees, this is not a change. It's always been the case. When you give them notice of the paid family medical leave law, you do need to get an acknowledgement in writing, and you do need to keep that as part of their file. The last thing on this topic is posters. You've got to have a poster at your place of work that addresses employee rights under this program. Now that we've got a change in the contribution rate, posters have got to change. So that is also available on the department's website. And something to be aware of, if you have non-English speakers, more than 5 employees who speak a particular language at your workplace, you've got to post the poster in that language. And those are also available from the department. So just be aware of that. The notice and poster issues, I think those are the big issues on this for this year. Okay, next topic is the Crown Act. So this is a new law, went into effect. It was passed over the summer in July and became effective on October 24th. So this is the current law in Massachusetts. And what this does is it prohibits discrimination based on natural and protective hairstyles. Okay. We have a definition here that I've got on the slide. It's going to be defined as a hair texture, hair type, and hairstyles, which shall include, but not be limited to, natural and protective hairstyles such as braids, locks, twists, bantu knots, and other formations. So what you want to keep in mind here is the purpose of this is to protect against discrimination based on hairstyles that have historically been associated with somebody's race. Okay, so there's been a lot of complaints over the years of employees who are told, hey, you got to change your hairstyle. That's not acceptable in our workplace. And the complaint has been, hey, this is something that's associated with my race. It's something that I should be allowed to wear as my hairstyle. And so that has now been addressed through the Crown Act. And 17 other states have enacted basically the same law that we have here in Massachusetts. And the way that it works is it inserts this phrase, natural or protective hairstyle, into the lists of sort of protected categories. Okay, so in the laws that address discrimination in housing, in employment, in lending, those types of things, when you have protections for race, sex, natural origin, those kind of things, now the term natural or protective hairstyle is going to be included in those lists. And just sort of a practical tip here, if you're going to make an employment decision based on somebody's hairstyle, and whether that's hiring, or you're going to say, hey, you got to change the way that you look here, just be careful with that. The world is kind of changing with dress codes and everything like that. And this list in the definition is not exhaustive. So any hairstyle that's associated with somebody's race is protected by law. So I think you just want to give some thought, like, do I really need to prohibit this person from wearing their hair the way they want to? My guess is you probably don't. So this should, if you're going to make an employment decision based on that basis, somebody's hair, just give some thought to it. And then you may need to do some research on whether that hairstyle is historically associated with somebody's race. Okay. Okay, next topic. Well, I guess one thing back on the Crown Act, make sure to so look at your policies, your anti-discrimination policies. You want to mention this in those policies. Talk to anyone who's in charge of hiring so that they're aware of this when they do interviews, that kind of thing. Make sure that people who are that are in charge of hiring and are managing, are aware of this change. Okay, next slide, please. This last topic concerns the Massachusetts Wage Act, and this is not a new law. This is something that's been in place for decades, but it was an important change this year in a decision that the Supreme Judicial Court decided. So I wanted to raise it for all of you. So just a brief refresher on the Wage Act. What it requires at the core is that people get paid on time and the full amount that they're due. Okay. And so people, you can pay weekly or bi-weekly, and you need to pay people within 6 or 7 days, sort of depending on the circumstances of the end of the prior pay period. And this is a very strict law, one of the strictest, if not the strictest, in the nation. And there are really harsh penalties for paying people late. And as the Supreme Court discussed in this decision that I'm going to talk about, people rely on getting paid on time for their bills, for their mortgage, for tuition, for groceries, for everything like that. It's extremely important. And so the law that we have in Massachusetts is extremely protective of this, okay? And wages is defined very broadly. So it's not just your straight time wages, it's overtime, it's commissions, virtually any earned pay, vacation included, are going to be considered wages. So people have to get paid on time. And this is a very important thing for employers. So the decision that came out this year, and we can go to the next slide here, it's called Reuters versus the City of Methuen. And what happened here was the city terminated an employee, and the law says that when you terminate somebody involuntarily, you fire them, they need to be paid everything that they're owed that day. And that includes things like accrued vacation time, okay? So the city fired this employee and they didn't pay her accrued vacation. It was a pretty significant amount. I want to say it was like $8,000 or so that this employee was due. Didn't pay her the day that she left. 3 weeks later, somebody woke up to this, or they got their ducks in a row, and they paid the straight time vacation that was due. So this employee has now received all funds that she was entitled to, but it was 3 weeks late. So a year or so goes by, and the city gets a demand letter from an attorney who says, hey, under the law, if you don't pay employees on time, you owe 3 times the damages, and you've only paid her the straight amount. She's owed triple. And by the way, you also need to pay her attorney's fees. That's part of the law. So the question in this case became, is somebody entitled to the triple damages, this very harsh penalty that we have, before they filed a lawsuit? There was some language in the law that led a lot of people, including myself, to believe that if the employee had not yet filed a lawsuit and you paid them what they were due, that they were not entitled to those triple damages, okay? So that was the question here, is does the person have to file a lawsuit to be entitled to triple damages, or are they entitled to that money as soon as the payment's late? And so the SJC said, once you pay somebody 1 day late, they are owed 3 times that amount. They do not have to file a lawsuit. And so the city here did not pay this person their accrued vacation time when they let her go. They were late. And so automatically, it does not matter if she filed a lawsuit or not, they owe her triple. And if her attorney needs to get involved, they owe the attorney's fees. So obviously this is a big deal. You got to make sure that people are getting paid. And where you see this come up a lot is with overtime. So if the employer isn't classifying somebody correctly. So they think, well, I'm paying this person a salary, they're exempt from overtime. Well, that's actually a complicated analysis. That's not necessarily the case. And if you do it wrong and you're not paying someone overtime, they maybe do a lot of money. And a lot of times, if it's the case for one employee, it may be the case for a lot of employees, and they may bring this as a class action. So you'd be amazed at how fast these numbers can start to really become big if you're not doing it correctly. And in Massachusetts now, the law is it's not really a change in the law, but it's now clear interpretation that if you are late at all, you owe 3 times that amount, whether they sue or not. So this should be a real wake-up call to all employers to look at your pay practices, make sure you're classifying people properly with overtime, especially because that's where we really see this come up. So that's it for the Massachusetts updates this year, and I'm going to pass things over to Sal.
Great, thank you, Jamie. As always, it was a pleasure.
My pleasure, Sal.
Okay. Okay. So I'm going to be talking about some New York legislative updates. So we're talking not just about New York City, although most of the updates tend to be from New York City, even more so from the state. But New York is interesting because New York, similar to Massachusetts, New York tends to give you a bit of insight into what's to come in the future in other states where you may have employees. So there are a couple of laws. So let me just mention them real quickly. We have New York City's Automated Employment Decision Tools Law, which is an interesting law. We have New York's Employee Electronic Monitoring Law. That's a New York State law. And we have amendments to New York's Paid Family Leave Law. And there have been state, city, and county pay transparency laws that have been implemented. Now, I'm not going to get too much into those because Alyssa Ferrione and I will be speaking about pay transparency laws this afternoon at 12:50 p.m. But we could certainly address it. Next slide, please. Okay. New York City's Automated Employment Decision Tools, AEDT. We actually wrote about this on our blog when it first came out, and I didn't expect that there would be much interest, as much interest in this law as there ultimately turned out to be. It was actually very, it was picked up by several media sites, and it caused people to comment quite a bit about it. So what is this? What is an AEDT? Well, AEDT really refers to a tool that is based on artificial intelligence. Okay, and it involves the use of this artificial intelligence or technology to automate aspects of the hiring, the recruitment process, the hiring process, and also to help determine whether a particular person or a particular candidate can succeed in a job. Okay, sounds a little scary, and that's because while it saves a lot of time, okay, to use these tools, if it's done incorrectly, you could end up having it result in a disparate impact to either women, to racial minorities, to people of a certain age. Essentially, it's intended. Okay, these tools are intended to reduce bias. Okay, but remember, garbage in, garbage out. if your metrics are not correct, or if something is off, you could end up perpetuating bias, the very biases you're trying to avoid. So just to give you an example of how larger employers have let's say benefited, or the impact that these tools have had on larger employers, I'm going to talk about Unilever. Unilever reported that once they implemented these tools, they reviewed over, and I'm just looking at my notes here, they reviewed over 250,000 job applications, okay, which under normal circumstances prior to these tools, or prior to using these tools, would have taken them 4 months to go through, okay? Thanks to tools such as these, it took them only 4 weeks to go through it. So basically in a quarter, it took them a quarter of the time, 25% less time, or rather only 25% of the normal time to screen 250,000 applicants. Now, I can't think of one of my clients, any one of my clients, except for, well, actually one, that utilizes these tools. Again, these are tools that larger companies use, right? And also tools that employment agencies use. So it's going to affect you to some extent when your vendors or your the employment agencies you use for recruiting talent are using these tools, because ultimately that could result in a problem for the employer. It's not without its controversies. Okay, as I mentioned earlier, there is a potential for bias in using AI or these tools. For example, Facebook had a real problem a few years ago when in its Facebook ads application, it basically it said that it turned out that job advertisements for nursing and teaching positions could be set or manipulated such that only women or women of a particular age group would see the advertisements. Okay, as a result of the outcry, Facebook removed that function from its tool, its Facebook ads tool. All right, so having said all of that, the technical definition that the law provides for an AEDT is any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified input, including a score, classification, or recommendation that is used to substantially assist or replace discretionary decision-making for making employment decisions that impact natural persons. Okay, so this is real heady stuff, and this is sort of like sort of like Star Wars stuff, and we're not expected to totally understand it. I mean, we're not computer scientists, but it's certainly something that that appears to be the wave of the future. Next slide, please. Okay, so the law in New York City is effective on January 1st, so in only a few weeks, and by that time, employers and employment agencies that most employers rely on need to complete an independent bias audit of all AEDTs. You will not be able to use one of these tools, okay, unless you conduct this bias audit. And if you are using these tools, you have until January 1 to audit them. You need to provide a publicly available summary of audit findings. As in other employment law areas, transparency is a big deal. Okay, and it's not just New York that's promoting transparency, but it's other states. So we want to make it, or you'll need to make it, a publicly available I was going to say publicly available to the public, but that's a bit redundant. And it needs to provide notices to candidates and employees who reside in New York City about the use of these tools. And it needs to be able, you need to be able to provide an accommodation to an employee who requests that they be accommodated in having these tools apply to them, which I'm not really sure. I mean, as far as an accommodation is concerned, I think that's going to be very, very difficult to handle. And New York City still has not issued supporting or regulations or guidance in this area. So there's certainly going to be more to come. Next slide, please. Okay, so who does this apply to? It applies to tools that we just discussed. It's not clear, okay? It's not clear if it applies to employers who are physically located in New York City or just to decisions related to jobs located in New York City. So there's still a lot of unanswered questions here. But it will apply to employees for not only for jobs, for hiring, but for promotion within the city. Next slide. Again, audits have to be completed by January 1st. And it requires the audit it can't be done in-house. It requires an independent auditor that assesses the tool's disparate impact on people of a particular gender or race. As many of you know, when we talk about intentional discrimination, we're talking about disparate treatment. Disparate impact is different. It's illegal and it's something that you need to monitor, but what it relates to generally is a neutral or what is seemingly neutral criteria, okay? But it nevertheless results in a disparate impact to a particular group. And that's what the city council is trying to avoid by implementing these tools. Hopefully we'll have more guidance soon from the New York City Department of Consumer and Worker Protection, which used to be known as Department of Consumer Affairs, but is now picking up some responsibilities as they relate to workers and worker rights. That's been something that's been going on now for a couple of years. Much legislation that has come down in the last 5 years has been transferred to the Department of Consumer and Worker Protection, as opposed to, let's say, the Department of Labor or the New York City Commission on Human Rights. So this agency, which, based on its prior name, I mean, you could tell dealt with consumer affairs, has really expanded its reach to include to cover employment issues. Next slide, please. Oh, did we skip one there? Okay. Oh, I guess. Oh, here we go. No, we did. We skipped one. Okay, next slide. All right. Yeah, so you have to provide, under this law, you have to provide at least 10 days notice before using the tool, and that the tool will be used to screen applications and what the tool will consider. So you're really going to need to know what these tools do before you start doing them, because you're going to be called upon to report what it is that they do. Okay, next slide, please. Okay, a violation, each day that there is a violation will count as a new and separate violation. So if you're using a particular tool, and let's say it relates to a particular job search, each day that tool is up and running is considered a separate violation. And so these issues can add up in terms of damages. Next slide, please. All right. So here are the violations. When you consider the daily fines for each violation will range anywhere from $500 to $1,500. I would imagine that first-time violations would result in a $500 violation. An employee or an applicant cannot bring a lawsuit. The only remedy for them right now is to file with the Department of Consumer and Worker Protection. Next slide. Okay, so again, your recommendations that we have for this right now is, get somebody who really understands these tools, to explain them to you, and to try to determine how they will track and maintain the data, because at the end of the day, like anything else, not knowing how these tools work and is not going to be a defense to a disparate impact circumstance or situation. Next slide, please. All right, the New York Employees Electronic Monitoring Law. This is something that I've always, or we've always told our clients in not just in New York, everywhere, in Connecticut, in Massachusetts, in New Jersey, that before you start electronically monitoring an employee, it's important to let them know that you're monitoring them. In New York, it wasn't necessarily clear whether you needed to. Well, now, effective May 7th, every employer must provide notice of electronic monitoring practices to all employees upon hiring, and with a written employee acknowledgement, and it needs to be posted conspicuously together with your other posters, employment and labor related posters. Next slide. Okay, it extends to telephone conversations, email communications, and internet access. Okay, so it's very important that although you may already have done this, you need to be a bit more vigilant now in making sure you have signed waivers and not waivers, but signed acknowledgement and proof of notification of to employees. Next slide. The state attorney general has enforcement authority. There is no private right of action. Okay, so employees would not be, employees would not be able to sue for violations. Nevertheless, the state attorney general would, and the current state attorney general's office is very, very active in pursuing employment related claims and labor issues. So that's something to take very, very seriously. Next slide. Okay, all right, next slide, please. All right, so there are some amendments to New York's paid family leave law. Effective January 1st, 2023, the New York paid family leave law has modified the definition of family member, and it's been expanded to include siblings, okay? Biological siblings, adopted siblings, step siblings, and half siblings. Now, this is a big change from what the law was previously, and it's a big change from what the federal FMLA, what the Family Medical Leave Act requires. The FMLA does not include siblings, okay? But the New York paid family leave law has now expanded its reach to cover siblings as well. And I think that will probably happen under the FMLA as well. I think this is a very important change, and I think it is reflective of New York's sensitivities to persons from other cultures, okay, where extended families are important and are just as close-knit at times as nuclear families. So this is a big deal. Next slide, please. Okay. There's been amendments also, and this was something that was already built into the paid family leave law initially. Employees who take paid family leave receive 67% of the of their average weekly wage, but it's capped at 67% of the New York State average weekly wage. Okay. In 2023, the New York State average weekly wage is $1,688.19, which means that the maximum benefit that employees will be able to recover under the paid family leave law is $1,131.08. Next slide, please. So please review and revise personnel policies related to paid family leave to account for the expanded uses. One of the things that I think is important to do is, if a law has these built-in increases, okay, like the New York paid family leave law, it's probably not the best idea to specify, for example, what the New York average weekly wage or what these outside indexes are in your employee handbooks, because they change, and you could end up inadvertently providing employees with incorrect information, since these things do change annually. But it's something that you absolutely should take a look at, just to make sure that if you have listed these indexes like the New York average weekly wage, that you go back to your policies and handbooks and modify them for 2023. And the same applies with the changes to the minimum wage that are set to take effect on December 31st, 2022. Currently, the minimum wage in New York City and Long Island and Westchester is $15 an hour, and that's not going to change. Okay, that's going to remain the same. The remainder of New York State, outside of Westchester County and Nassau and Suffolk counties on Long Island, is currently $13.20. That's going up to $14.20. So that's something you need to keep in mind for employers who have employees in upstate New York and Syracuse and Troy. These are things that you absolutely need to take into account. Next slide, please. Okay, the New York wage transparency laws. I'm just going to cover this real quickly. New York City has one. Okay. Westchester County has one. Westchester County's transparency law, like New York City's, went into effect on November 2022. They're virtually identical. Okay. The New York legislature passed its own legislation on statewide wage transparency that is just waiting for Governor Hochul's signature, and that would be effective 270 days later. It hasn't been signed. I'm not really sure why it hasn't been signed. I'm actually surprised that it hasn't yet been signed, because it's been awaiting her signature for a few months now. But we'll talk more about that this afternoon during the pay transparency session, and we can get into some more specifics. Next slide. Okay, and that's it. That's it for us on the legislative update world. I'm going to be speaking again at 10:40. Since we did finish a little bit early, I'm thinking that we probably should take a break. I don't mind jumping in. Tricia, what do you think? I don't mind jumping in. People are logging in and logging out. I want to stick to the schedule.
Yeah, I agree. If there are no questions, and I assume that we don't have any questions on any of this.
We were so clear. It has nothing to do with whether or not the topics were exciting, right?
I do have a comment myself. Two comparisons of Massachusetts law versus Connecticut law. So the first thing that really struck out that jumped out at me was, Jamie, this recent case in Massachusetts regarding the pay law. That is really harsh and really strict. And I'm quite surprised because that is not the same in Connecticut. If there is an opportunity under the statute for an employer to obtain double damages and attorney's fees under our wage statute, but it has to be proved in court, and the employer has defenses that it can assert, such as good faith, if they made a mistake and they paid it back as soon as they realized it was a mistake, then there are possibilities for these defenses, and then the plaintiff would not obtain the double damages and the and or attorney's fees. So to me, this is a really harsh penalty, and Massachusetts employers need to be aware. If you have operations in Connecticut and Massachusetts, understand that Massachusetts has very strict enforcement procedures and policies for failing to pay. And in Massachusetts, it's on the day of termination, right?
That's right. Yeah, if somebody's terminated involuntarily, then they need to be paid everything they're due that day. So what we would say there is, if you're not in a position to pay somebody that day, and somebody's done something, whether it's a disciplinary issue or whatever it is, I would suspend that person until you're ready to pay, because you don't want to terminate if you can't pay that day.
That's excellent advice. And as a reminder to everybody in Connecticut, if there's an involuntary termination, the requirement is that the person be paid the next business day. So we usually advise that it's just easier if you can pay them on the day of termination, and you pay them through, the date that they have worked that day, the time they've worked that day. And so that way you don't have the logistics of how are we going to get them the paycheck the next day. If it's a direct deposit, you could do it by direct deposit, but it's got to be in Connecticut next business day, in Massachusetts the day of the termination. So I just found that to be a really fascinating difference between the enforcement positions in Connecticut and Massachusetts that employers with operations in both states need to be aware of. The other thing, of course, you mentioned is the Crown Act, which has been applicable law in Connecticut for at least a year. And I haven't had a lot of claims on that. I think most people are aware of the law in Connecticut, aware of how it would, how to enforce it. It's not to say that if you're in a situation where somebody, where employers, rather with employees with, say, long hair, need to wear a net because of operations or safety reasons, that kind of thing is not prohibited. What's prohibited is specific discrimination against somebody because of a traditional hair related to race. And I think it's a really interesting and fascinating kind of law, that is another point of discrimination law. But I haven't had any direct questions on that, because I think most employers will have a neutral policy if, say, hair nets are required, and or if there's any other, issue that relates to hair. If it's a neutral policy that's not going to impact somebody directly because of their race, then those would be enforceable. I see that we're getting a couple of, go ahead, Sal.
Yeah, no, I see we have a lot. So let me just answer a couple of these real quickly. By the way, one thing I didn't mention, because I just found out about it today, was that New York City is trying to the New York City Council is trying to push through a law called the Secure Jobs Act, which I wasn't aware of until early this morning. And in fact, it's only been the last 24 hours when words come out about this. The law or the ordinance is looking to do away with the at-will employment in New York. So basically, they're looking to convert all employees to for-cause sort of employees, and they're trying to adopt. The proponents of the ordinance are trying to adopt the situation similar to what we have in the EU with the European Union, which I think is a terrible idea because the EU has had terrible results as a result of it. It affects younger workers, younger employees right out of school, because the way around these laws is to give these new employees temporary contracts that are set to expire. So I can't imagine. I mean, listen, 10 years ago, if you told me someone would try to do that, I would have laughed. Now, I take it a little more seriously, but I still don't think that's going to happen. So let me just cover a couple of questions here. So the PowerPoint, everyone will have access to the PowerPoint and copy of the slides. I see that questions come up quite a bit. Okay. Can you clarify which state is increasing paid leave contributions effective January 1? All right. So Connecticut is increasing as of, I believe, June 2023, so not January 1, 2023, New York, although New York is expanding the benefits, their contribution rate is going down. So, which is a good thing. That means that that the program is able to support itself a little bit better. And I'm not sure, I don't have in front of me what the situation is in Massachusetts. Jamie?
Sal, yep. So that's something that I hit in my talk. The rate is also decreasing in Massachusetts just a bit. So it's set out in the slides, and it's also on the Department of Family and Medical Leave's website. But those rates are going to go down a little bit this year, starting on the first of the year. So
Okay.
that's something that,
And that's right.
yeah. So employers definitely want to be on top of that, because when you start withholding from paychecks coming up the first of the year, you want to know those proper rates.
Right, and that's a good point. And I think the reason for Massachusetts and New York, and this was probably the intention, is because those programs have been in effect longer than Connecticut's has been. So it's good to see that it's not like the toll, getting on a bridge. It's not just going to keep increasing. It's going to stay the same. Another question, the expansion.
But Sal, before you get there, just so everybody knows, in Connecticut, the benefit is going up. So the benefit went up on I think July 1 to $840 a week, and it's going up again on June 1 in 2023 to $900 a week. So everybody should be aware of that.
That's the case. That's the case in Massachusetts too. The benefit itself is increasing when you make a claim to the state program, but the contribution that the employers and the employees make is decreasing.
Got it.
And Sal, the next question, I see a question about the non-compete law regarding physicians. That is the existing law, and you can find that. It's in the Connecticut General Statutes. It's 20-14P, which is scary that I can cite that off the top of my head. The geographic restriction right now is 15 miles. So it would be 15 miles from any of the facilities at which a physician works. So if the physician is principally located in one facility, then it would be a 15-mile radius around that hospital or that area. But if the physician moves from place to place and actually practices in more than one location in a group, then you can expand the range then. But the strange thing is it's likely to be defined by where the doctor practices, not by where the employer has locations. So if you happen to be a group that has offices in 7 locations across the state of Connecticut, you don't get to draw 15-mile circles around all of those. You have to look at where that particular physician principally works, and that's where the 15-mile geographic location would apply.
Just a note on that, in Massachusetts, we have a statute that explicitly says you can't have a non-compete for physicians.
Okay.
Okay, let's see, what else do we have here?
We'll talk about what's coming up next.
Yeah, we could do that. And I think we're going to post it also. But so I'm going to be talking next about performance conduct and behavior standards under the ADA. Trisha Riley will be talking about aging at work. After that, Emily.
And Sal, we can give the time too, so people who want to try to time their schedule.
Yes.
So, if we end early as we have here, we'll just take a break so that we stay on track in case people have planned their days around the schedule. But the ADA performance measurements will start at 10:40, go to 11:20. Aging starts at 11:20. Free speech in the workplace starts at 11:50. We have a scheduled lunch break from 12:20 to 12:50. Starting up again with paid transparency at 12:50. Paid family medical leave at 1:20. We have ERISA starting at 2. And we have immigration starting at 3, which is supposed to end at 4, and our closing remarks are at 4. But again, if we end early on immigration, obviously we'll close for the day early. Everything else, we will not start ahead of time in case people have planned their schedules around the agenda. It's highly unusual for us to be ahead of schedule, so I'm very proud of ourselves.
I know.
As we said at the beginning of the presentation, oh my goodness. there aren't as many, as you all know, the big, headline last year when we gave this presentation was paid family medical leave. And quite frankly, last year we were still addressing a lot of COVID issues. And we did consider whether to have a separate section on COVID, but we decided instead that we would broaden the issues to be, to go under the laws that are really applicable. So in other words, when Sal gives his presentation next on ADA standards, as we all know, long COVID can be an ADA, can be a disability under the Americans with Disabilities Act. So the general principles that we're going to talk about in our ADA presentation, and even to some extent the aging presentation, are going to be ones that would apply to somebody, for example, with long COVID. And so what we are seeing now, and I don't want to take the wind out of Sal's sails, but one of the reasons that we decided to address, sort of COVID within the context of an ADA umbrella is that we are seeing in this back to work context, we're seeing requests for accommodation for long COVID. We're seeing a lot of mental health stressor issues as a result of returning to the work and hybrid and all that. So that's why we think it's really important to have an update on how to handle ADA issues, which are in our view, one of the most difficult things for employers to walk through. And that is one of the reasons why we're going to do that in the next segment.
Yep.
So that's a little kind of preview of what's coming up next.
Got it. Okay.
I think we're done, right? No other.
Okay, no, let me see. I'm looking here.
Oh, somebody just mentioned COVID. I didn't know.
How do you like that? How do you like that?
Right. So yeah, we don't. Yeah, if within any one of our sessions, particularly the ADA, if you have some specific COVID related issue that you want to raise, please feel free to do so. But we intentionally decided after basically 2 full years of doing many webinars addressing the ongoing and changing COVID issues, we decided not to do one this year. I will say, in addition to ADA issues related to COVID, the other things that I'm seeing are religious accommodation issues that are still being requested for employers who have necessary requirements for vaccinations. And that we are seeing not only, of course, for COVID, but also for flu vaccine. So, I have been reviewing those for healthcare clients in particular. Sal, I don't know if you're still getting religious accommodation.
I am. Fewer and fewer though, because because restrictions are loosening. Although OSHA for a lot of our long-term care clients, it has really ramped up targeting to ensure that COVID protocols are still being followed. So again, a reminder in that area is that a lot of prior to COVID, the focus was always on what DPH was doing or what DPH was requiring, but you really need to also focus on OSHA, because OSHA's concern is again more about the employees than residents or clients, but it's something that you really need to consider. I do want to mention before we go out on break, we have, as many of you know, we have an employment law blog that's pretty active, and we address these issues as they come up all the time. So I'm going to suggest that you go and subscribe by email. It's called Employment Law Perspectives, Murtha at Work, and you can access it by typing in, and you're going to see a link in a bit, but since we have some time, murthaemploymentlaw.com. Okay, and I promise it'll be worth your while. It'll be a page.
And that's where we'll put in those updates. That's where we'll put in updates too, Sal. We'll put in updates there because we are keeping an eye on these non-compete statutes, and that's going to be, I think that's going to be the hot button topic for next year. So if you want to get a little bit of ahead of time and information ahead of time. Let's keep an eye on that, especially as Connecticut usually does. They roll these things to make them effective as of July 1 of every year. So if this does get enacted over the winter, we'll be looking out for that to see if there are going to be any changes for next year.
That's right. A real screen scroller. Okay, so let's take right, Tricia, we take a
Yes.
little bit of a break and come back. We'll all get back on at 10:40. Okay, folks?
Great. And in the interim, if somebody could post the employment law blog,
There we go.
yeah, email if that hasn't gotten in there yet, or how to subscribe. That would be really helpful so that everybody has it on the chat. Okay, great.
Hey, folks.
Okay. All right. See you all soon.
Thank you.
Thanks.
Bye-bye. Okay, folks, we are back. It is now 10:40 a.m. and I'm going to be speaking to you about applying performance and conduct standards to employees with disabilities. A couple of things that I want to pose. Or I want to present first before we go forward is, remember, when we're talking about disabilities, we're not only talking about physical disabilities, we're talking about emotional and mental disabilities, and we're also talking about things like alcoholism. Okay, can we go to the first slide, please? Okay, we're going to discuss the basic requirements under the ADA. And although we're going to be focusing on the ADA, which is the Federal Americans with Disabilities Act, the state laws, Connecticut, Massachusetts, and New York state laws are also apply in these circumstances. And in fact, there are more impairments are considered disabilities under those state laws than they are under the federal law. We're going to talk about performance standards. We're going to talk about conduct standards and seeking medical information. Next slide, please. Okay, so what are the basic requirements under the anti-discrimination laws? So under the ADA and Connecticut and Massachusetts and New York state laws, employers are prohibited from discriminating against what we call a qualified individual with a disability. Okay, we call that shorthand. We refer to that as a quid. Okay, so it's not just a matter of having a disability, but the employee is, notwithstanding or despite the disability, is still able to perform the job, the essential functions of the job. So what is a disability under these laws? Well, it's a physical or mental impairment that substantially limits a major life activity. It's having a record of such an impairment or being regarded as having such an impairment, whether or not you actually have one. Next slide, please. Okay. What's a qualified individual as part of the qualified individual with a disability? Well, a qualified individual is someone who possesses the requisite skills, education, and experience for a particular position, and they must be able to perform the essential functions of a position with or without a reasonable accommodation. They're not required to perform every function of the job in order to be deemed qualified. They need to perform the essential functions of the job, which requires, obviously, you to determine what functions of a job are marginal and which are really, really important in order to make this the determination of whether or not a reasonable accommodation is possible. Next slide, please. Okay, so we all know that employees are entitled to reasonable accommodations, and generally speaking, employees are obligated to request a reasonable accommodation in order to start the interactive dialogue that takes place. Once requested, employers must either grant the accommodation without further consideration, or engage in this interactive dialogue to determine whether the alternate accommodations exist, or whether the accommodation that the employee is requesting would pose an undue hardship on the employer. Again, you're not required always to agree to the employee's proposed accommodation if in fact there is an alternate accommodation that will accomplish the same result for the employee and would not result in undue hardship on the business itself. Although I mentioned earlier that employees are obligated to request a reasonable accommodation, that's sort of a general statement, because an employer may be required to initiate discussions with an employee under certain circumstances. For example, when HR or the employer is aware of the disability and or the possible need for an accommodation. Okay, next slide, please. Okay. The assumption under the anti-discrimination laws is that an employee's disability should really have no bearing on performance standards or on conduct standards. And in the majority of cases, these standards should be treated or addressed the same way as they are for employees without disabilities. Okay. The purpose of providing accommodations or reasonable accommodations is to address disability related performance or conduct issues so as to allow the employee to meet performance goals or avoid conduct problems. Again, you're not always going to have these problems, right? But I do get a lot of calls from clients asking me how to deal with particular situations when it's believed, at least, that the performance and or conduct issue is being caused by the disability. Okay, so it's a bit of a concern for employers and how to address these things without running afoul of the anti-discrimination laws. One thing we have to keep in mind is that reasonable accommodations don't exist to excuse or tolerate performance or conduct problems. Okay, you're not required to throw the performance or conduct rule book out the window when dealing with an employee with a disability. Next slide, please. Okay, so how do we ensure that our performance standards are being satisfied and that they are legitimate? Okay, we refer to these as qualification standards. So we all establish job-related requirements. Okay, for example, specific training, license, or certifications, and all jobs will require certain physical or mental sort of qualifications, such as vision, hearing, or lifting. Job requirements are going to generally entail meeting health or safety requirements with the job, and also the ability to work well with others on the part of a team, and that tends to be an important requirement that seems to come up quite a bit in the context of what we're discussing. Next slide, please. Okay, so job-related requirements typically include, in addition to what we just discussed, specific tasks, job duties, or assignments. Okay, this is what I was referring to earlier when we talked about the essential. We all know what the essential function, we think we all know what the essential functions of the job are. Okay, but sometimes we make the mistake of assuming that certain marginal functions of the job are likewise essential. Okay, and it's important to make that distinction when you're considering reasonable accommodation requests. And you're always allowed to establish evaluation methods that not only take into account essential duties or essential functions, but also the marginal ones as well. Next slide, please. Okay, so when we talk about production or performance standards, we're talking about both quantitative and qualitative standards. Qualitative standards relate more to certain output. Quantitative standards relate to output. Now, lowering or changing a production standard because an employee cannot meet it due to a disability or because of a disability, that's not considered a reasonable accommodation. Okay, you're not required to eliminate those standards. It's important, which is why it's important for employers to provide clear guidance to an employee with a disability, as well as all other employees, regarding the quantity and quality of work that must be produced and the timetables for producing it. Okay, so next slide, please. Okay. If an employee or applicant cannot meet a specific qualification standard because of a disability, the employer will still be required to establish that the specific qualification standard that the employee or applicant is unable to meet is, quote, job related and consistent with business necessity. Okay, so that's a very important, and we're going to talk about that a little bit more. Is the performance standard a real performance standard? Is it necessary for the job? Is it job related? Okay, these are things you need to ask yourselves. You can't simply just claim that someone did not follow a technical standard when in fact that standard is really not material or important to the job. Next slide, please. Okay, so you need to review job descriptions on a periodic basis just to make sure that functions that are designated as essential are not just marginal. It's not enough that just because a particular function has been designated as essential, that it is essential. Okay, you know, how important are timelines? How important are deadlines to a particular task? So not only do you have to identify, or should you identify, which functions are considered essential and which are considered marginal, but they really have to reflect, reality in those circumstances. Supervisors need to evaluate job performance of an employee who has a disability in the same way that they would evaluate any other employee's performance. Okay, and failure to provide an accurate, fair evaluation could result in an employee's inability to prove, and if necessary, to request a reasonable accommodation. And that's really what we want. We want to keep the doors open to requesting, to timely requesting a reasonable accommodation. One of the things that we want to avoid, and this is primarily what we're going to be talking about in the next half hour, is reasonable accommodation requests that are not timely made, but that are made after a problem already arises. And those can be challenging. Those can absolutely be challenging to address. So next slide, please. Okay, so here's a scenario, and this is exactly the kind of thing that a lot of us face. The employee never mentions a disability, but ultimately discloses a disability in response to a lower performance rating. Okay, so the employee receives a negative evaluation or a lower performance rating. What does a supervisor do in these situations? No one is aware of the disability until the employee has decided to raise it in response to a low performance rating. Okay, so first of all, the supervisor in handling or in addressing this should not focus on disability at all. Okay, the performance rating must reflect the employee's performance regardless of what role, okay, if any, that disability may have played. So that's the first ground rule that we need to make, that we need to establish. The supervisor should make clear, okay, to why the employee received the lower performance rating, or why the supervisor is going to be required now to focus on this performance problem. Again, without regard to any disability or any impact that a disability might have on that performance rating. Okay. Again, best practice, the supervisor should reiterate what the employee must do to improve performance. Okay. Now, if after the employee has disclosed this disability in response to a lower performance rating, and the employee does not accompany that with a request for an accommodation, the supervisor may ask whether there is an accommodation that might help raise the employee's performance level. Okay, so you're not necessarily you're not ignoring the disclosure of the disability, but you're also you're going forward with the performance review as if the disability doesn't exist. But you cannot forget to address the reasonable accommodation request. And if there is no request, then you can start the ball rolling by asking the employee whether there's an accommodation that would help raise the employee's performance level. Next slide, please. Okay, here's another scenario, which okay, is similar to the first one. The employee asks for a reasonable accommodation in response to a lower performance rating. Now, ideally, we want employees to request reasonable accommodations before problems arise or performance problems arise. They're not required by law to ask for a reasonable accommodation at any particular time, okay? But it's easier for us and it's better for the employee if we are aware that there's a disability that could impact a qualified employee's performance, okay? So what happens? There's a lower performance, there's a low performance rating or a poor performance rating, and the employee asks in response, can I have a reasonable accommodation? Okay, well, you're not required to rescind any discipline that you've thought of imposing, even if the discipline itself takes the form of a termination. Okay, and that's very, very, very important. Now, I'm not recommending to anyone that they actually go forward and continue with a termination under those circumstances. I do think you need to, there are a lot of factors to consider, including speaking with counsel about whether or not there are any risks. But I don't want anyone to assume at that point that once the request for a reasonable accommodation is made under this scenario, that you have no choice but to stop all discussion about termination or other discipline. Okay. Now, what you cannot do, and I have seen this, is that employers cannot refuse to discuss a request for a reasonable accommodation or fail to provide a reasonable accommodation as some sort of punishment for poor performance. You're not allowed to do that. Okay. Now, if the performance issue doesn't rise to the level of a terminable offense, okay, the employer can proceed with the discussion or evaluation, but should also begin the interactive process to identify a reasonable accommodation. Okay, so here the distinction is on how you act is, well, is this a terminable offense? Is there some other sort of discipline available? And that'll dictate how you proceed, okay, in terms of the employee. Next slide, please. Okay. If the employee, here's another scenario. If the employee asks for a reasonable accommodation, oh, this is the same scenario. The reasonable accommodation should be determined and implemented as quickly as possible. You need to move quickly on something like this, where an employee requests a reasonable accommodation in connection to a lower performance rating. And the reason why you want to act quickly is that there's going to be a lot of anxiety on the part of the employee because now they've just been warned, right? They've received a performance warning and they seemingly would be anxious to improve their performance. And you don't want to delay the reasonable accommodation if by doing so, you're perpetuating the poor performance, and then you ultimately have a basis to terminate the employee, because that's when you'll get hit with a claim for a reason for failure to provide to grant a reasonable accommodation request. Okay, so remember, timing is very important. Implement those measures very quickly. Now, where an employee fails to give notice of the need for an accommodation until after a performance problem arises, even though you're required or that you need to address reasonable accommodations requests or initiate the dialogue, what you're not required to do is tolerate any poor performance or excuse it. You're not required to withhold disciplinary action that is warranted by poor performance. You're not required, and you shouldn't raise a performance rating based on a disclosure that someone's disability was the cause of a lower performance rating. And as in all situations, you're not required to provide an evaluation that doesn't doesn't accurately reflect the employee's performance. Next slide, please. Okay, so here's another scenario, and this is a common one as well. Okay, An employee requests the removal of essential functions or changing the performance standards involved in a position as an accommodation. Okay, and I think it's easy to say, although more difficult to implement, that the ADA, neither the ADA nor state anti-discrimination laws require an employer to remove an essential function or to modify performance standards. Okay, temporary removal of an essential function or otherwise lowering a quantitative standard is generally not recommended. I don't recommend it, except if it's clearly done only for a short, definite period of time because of temporary medical issues that are not expected to last. Okay, so again, you can remove or modify functions of the job, essential functions of the job, but only if it's intended to be short term. Okay, and it's clearly defined. You do not want to get into a situation where that becomes commonplace, because at some point you're not going to be able to grant that type of an accommodation, and that's when you'll run into problems. And companies and employers do that. They do temporarily remove duties in connection with certain conditions. For example, in pregnancies, when someone has a heart attack. Okay, these are considered disabilities, but they're not necessarily intended to last to last a long time. Okay, especially pregnancy. Focus on accommodations that will enable an employee to perform satisfactorily the essential functions of the job and make them able to meet performance standards. Next question, please. Next slide, I meant. Okay, conduct standards. So we talked about performance standards, all right? Now, what about conduct standards, behavior standards, right? Employers can discipline an employee with a disability for violating a conduct standard if the disability does not cause the misconduct. That's easy enough, okay? If the disability is not the cause of the misconduct, we can discipline the employee regardless of the disability. That's an easy one. If the employee's disability, though, is the cause of misconduct or the violation of a conduct standard, and that standard is job related and consistent with business necessity, and other employees are held to the same standards, then the employee may be disciplined. Okay, so that's the extra step you need to take when a conduct issue, all right, is caused by a disability. And I'm going to give you an example in a minute, but it needs to be a conduct standard that relates to the job and that is really, really necessary for the job to go off without a hitch. Under those circumstances, the employee can be disciplined. Now, the ADA doesn't protect employees from the consequences of violating conduct standards or conduct requirements, even where the conduct is in fact caused by a disability. Next slide. What are we talking about when we talk about conduct standards? We're talking about standards that, and these are real, and these are, I would say, job related in most positions, and are consistent with business necessity. All right, prohibiting violence in the workplace or threats of violence in the workplace, prohibiting stealing or destroying property, preventing insubordination, requiring employees to respect clients, customers, and just the general public, prohibiting inappropriate behavior among coworkers. Okay, and prohibiting alcohol or illegal drug use. These are all job-related conduct standards. No one can really dispute that these standards are integral or important to business. Next slide, please. Okay, but some conduct standards. Okay, some conduct standards are very vague. For example, a standard that goes along the lines of, well, we expect you, we prohibit disruptive behavior. What's disruptive, right? We know threatening behavior or behavior that poses a threat to someone's safety. That's pretty clear. We know what that is. We know that's certainly job related. We know that's necessary to a business. But what does disruptive behavior mean? So in situations like that, we need to consider what conduct are we talking about? Is it a symptom of the disability or the disability itself that's affecting the conduct? And what's the work environment like? What job is this particular employee performing? Next slide, please. Okay, so here's a great example of something that I think many people can relate to in terms of a circumstance in the workplace. So let me read this. First, I'm going to have a sip of water. Okay, so Darren is a longtime employee who performs his job well. Over the past few months, he's frequently observed talking to himself, though he doesn't speak loudly, he doesn't make threats, and he doesn't use inappropriate language. However, some coworkers are uncomfortable around him, all right? And they complain to the division manager about Darren's behavior, okay? Darren's job doesn't involve customer contact or working in close proximity to coworkers, and his conversations do not affect his job performance. The manager tells Darren to stop talking to himself, but Darren explains that he talks to himself as a result of a psychiatric disability. He doesn't mean to upset anyone, but he cannot control his behavior. There's medical documentation that actually supports Darren's explanation as to why he talks to himself. The manager does not believe that Darren poses a threat to anyone, but coworkers are uncomfortable. So he transfers Darren to the night shift, okay, where he'll basically work by himself in relative isolation, and he'll have less opportunity for advancement. And Darren will justify this by saying that his behavior is disruptive, okay, to the workforce. So that's a very typical, normally these examples are kind of far-fetched, but I think this is something that a lot of us have had to address, okay? An employee whose condition makes other people uncomfortable, just because of the condition itself, not because of any consequences of that condition. Next slide. Okay, so the question I want you to ask yourselves is, was the manager's decision to transfer Darren consistent with the requirements of the ADA or state anti-discrimination law? All right, I'm going to give you a second to think about it, although I don't expect a response because this is not necessarily interactive. Okay, next slide. Okay. The manager's decision to transfer Darren was not consistent with applicable anti-discrimination law. Because why? Because under these circumstances, it's not job related and consistent with business necessity to discipline Darren for this quote unquote disruptive behavior. Okay. In addition to that, transferring Darren to the night shift based on his conduct would also be a violation of the ADA. While it's possible that the symptoms of an employee's disability could disrupt the ability of others to do their jobs, that's not the case here. No one has accused him of disrupting the workplace or their ability to perform the job. All right. Employees haven't complained that Darren's voice is too loud. They haven't complained that he's saying inappropriate things or that he's somehow hindering them from performing their job. It just makes them a little uncomfortable being around someone who happens to talk to themselves, okay? But their discomfort is not sufficient to warrant what Darren's manager did here, okay? So next slide, please. Here's another example, okay? A telephone company employee's job requires her to spend 90% of her time on the telephone with coworkers in remote locations discussing equipment installations. Okay, the company's code of conduct requires workers to be respectful towards coworkers. Due to her psychiatric disability, the employee, okay, walks out of meetings, hangs up on coworkers on several occasions, and uses derogatory nicknames for coworkers when talking with other employees. The employee warns the employer warns the employee to stop this unacceptable conduct, but it continues to persist. And when it does, the employer issues a reprimand. Next slide, please. Was the employer's decision to reprimand the employee consistent with the requirements of applicable anti-discrimination law? I'm going to give you all a second to think about that. This one's probably a little easier than the last one, or a lot easier. Okay, next slide. Yes, the employer's decision was consistent, okay, with what the law states. The employee's behavior violated a conduct rule that was job related and consistent with business necessity, and therefore the employer's actions were consistent with the ADA. Okay, so each conduct rule that the employee violated fell within that list we talked about earlier. It's pretty specific, right? They're rude to their coworkers. They're using derogatory language or inappropriate language or nicknames to refer to their employees. They're hanging up on customers. That's not what you want for a customer service employee. Okay, but what if the employee requests a reasonable accommodation after being confronted with this reprimand? What happens then? Next slide. Okay, you're not required to withhold the disciplinary action or change the conduct rule as an accommodation. Okay, you could still go forward with whatever discipline you were going to implement. Okay, but if the employee is not being terminated, okay, because again, that depends on severity of what in fact the misconduct entailed. You need to focus on the accommodations, assuming there are any, that will enable the employee to meet the conduct standard. Next slide, please. Okay, so let's sort of do a bit of a recap. All right, reasonable accommodation, timing of the request for a reasonable accommodation. Okay, if the request for a reasonable accommodation occurs after the performance issue or misconduct that warranting termination, if the reasonable accommodation is made after that fact, you can still proceed with the termination. Okay, if you weren't aware that this employee required a reasonable accommodation or suspected that the employee required a reasonable accommodation, then you could terminate the employee in response to that performance or misconduct issue. If the request is made after the performance issue or misconduct issue, warranting discipline other than immediate termination. In other words, it's not as serious. The violation was not as serious, so the performance was not as low as would be to trigger immediate termination. You may still impose discipline. Okay, but you do need to begin the interactive process, the interactive dialogue in discussing whether or not a reasonable accommodation is available for the employee. One thing we do need to keep in mind is that an employee whose poor performance or misconduct, including insubordination, is due to the current illegal use of drugs, okay, those employees are not entitled to a reasonable accommodation because current illegal users of drugs are not protected by the disability discrimination statutes. Okay, that's a very important consideration. Remember, it's important to handle requests for accommodations quickly and expeditiously. Next slide. Okay. When addressing these performance or conduct problems in the context of someone with a disability, where the disability could be the cause, focus on what the employee is doing wrong. Really be specific. What does the employer expect employees to do to improve? And what are the consequences if there's no improvement? Okay. I'm not saying, you should not raise the issue of disability, but only respond if the employee raises a disability, the existence of a disability, because you're raising it, saying, hey, are you disabled? Well, that could lead to what we call a regarded as claim. And remember what we said earlier, a disability is also defined as a claim that's regarded as a disability. So if you perceive someone to have a disability, for purposes of the law, that employee actually has a disability. Okay. So you need to be careful with that, and always keep in mind that you might have to defend your discipline to the EEOC, to the CHRO, to the New York State Division of Human Rights, to the Massachusetts Commission Against Discrimination. Keep that in mind. It's like when you're sending an email. Don't put anything in that email, or when you're sending a text to someone, don't put anything in that email or in that text that you'd be embarrassed to hear someone read out loud, right? So be careful, and keep in mind that you may have to defend the reasons you took certain action. Next slide, please. Okay, what about potentially violent conduct, right? Well, let's distinguish between real threats and behavior that's outside the norm. Okay, so we remembered earlier the employee, Darren, I think his name was, he talked to himself. Okay, he spoke to himself, and it made people nervous, it made people uncomfortable, but he didn't pose a real threat. Okay, maybe the behavior was outside the norm, but he didn't pose any real threat. Now, making threats obviously is misconduct that can be punished, regardless of whether it's attributable to a psychiatric disability or a disability due to substance abuse. Threats are always deemed misconduct. Don't assume that. One thing we always have to keep in mind is that we cannot assume that an employee with a particular mental illness will likely become violent. That's illegal stereotyping that goes without saying. If behavior is causing a problem, deal with it as you would any other personnel issue, and treat it that way as well. Next slide, please. Okay, so that's it. Let me see if there are any questions. If anyone has any questions. Let me see. Okay, so there's a question here. Would dyslexia be considered a disability? So here's the situation. The short answer is I'm going to say yes. Okay. So we're supposed to look at disabilities on a case-by-case basis, right? There are some disabilities that are automatically deemed disabilities, or rather some impairments that are automatically deemed disabilities. Someone who's unable to walk due to a spinal injury, that's automatically considered a disability. There are other disabilities or other impairments that aren't as clear. Okay, I'm going to say dyslexia is a disability, particularly if it prevents or substantially limits a major life activity under the ADA, which it likely does. If someone is, I often tell clients, don't focus too much on the actual impairment and whether or not it meets this definition of disability. Focus on whether the impairment is the cause for someone's performance or conduct, right? So that's one of the things that over the years the law has tried to back away from. Let's figure out whether something is an actual disability. That requires too much work on your part. Focus on the impairment. But yes, I think I would consider in most cases that for dyslexia to be considered a disability. Let's see. Do we have, well, we don't have, let's see. Actually, we are out of time. Oh, wait a minute. Here's a scenario. Wow, this is a long one, which I can't answer right now, but I will answer. It's a long question that I can't answer, but for now, I think we're ready for Trish Riley. Thanks
Very
for
good. Thanks for staying on
Thanks.
time, Sal. Greatly appreciate
surprised.
it.
I'm actually surprised.
It's great. Yeah, it's great. Okay, very good. So, this dovetails really nicely with Sal's presentation because the issues that we're going to discuss really are ADA issues. So first slide, please, Eden. Okay, so just by way of background, I was recently asked to present on aging in the workplace at the Connecticut Business Industry Association because they were finding that many of their members had this issue about how to deal with aging in the workplace. And they were seeing some correlation in certain kinds of jobs, particularly jobs requiring either manual labor or physical job duties that were becoming more difficult for people to do in the workplace. Some employers were also talking about aging issues that they are seeing in terms of memory. And so that could be in any sort of profession. So I gave this presentation and I thought I would do it again here because I think it is an issue that's very timely right now, given the data and the demographics. And what we know is that on the positive side, an aging workforce can mean experience, knowledge, and loyalty in terms of staying put, knowing the job, having that base of knowledge that's very important to the organization. It's important that employers not stereotype based on age, because age is not the problem. The problem, if there is any, would be in the performance of the essential functions of the job, which again dovetails nicely with what Sal was just discussing. Documented performance problems can be addressed and should be addressed, again, consistent with what Sal was saying, that just like under the ADA, and most of these will be ADA analyses, you can require workers to perform the essential functions of the job. Okay, next slide, please. Okay, here are some of the statistics. There is an aging workforce. Okay, these are CDC statistics. There is an aging population, which creates an aging workforce. And the employment of workers 65 or older and workers 75 or older grew by 117% in a span of 20 years from 1994 to 2014, which is when these statistics were available. Next slide. The frequency of occupational injuries among older workers decreases. Okay, the frequency decreases, but the injuries tend to be more serious injuries. So the projections are that the percentage of older workers is projected to grow based in large part on what the projections for the population are. And however, they still remain lower than those in the prime age group. Next slide. So, what are the applicable laws that we're going to be discussing today? We're going to be discussing the Age Discrimination in Employment Act, the ADEA, which prohibits discrimination against employees aged 40 or older. Connecticut state law has a similar anti-discrimination requirement under its law, but interestingly, Connecticut has no age range. It simply says that discrimination on the basis of age is illegal. So theoretically, that could mean a young cohort, people in their 20s, might claim that there's an age discrimination suit against them, or that they are being discriminated against on the basis of their age. In my 30 plus years of practice, I've seen only one such claim. So it is definitely the case that most of the age claims involve workers 40 or older. And in fact, most of the age claims that I have seen involve workers 50 or older. Okay, the other applicable law here is the Americans with Disabilities Act. Again, this is what Sal was just discussing. And Connecticut has a corollary statute to this under its anti-discrimination law, in which it's discriminatory to, it is illegal to discriminate against someone on the basis of a disability. However, there may be also issues of how to accommodate a disability in the workplace, and we'll talk about that as well. So what's interesting is Connecticut's statute does not explicitly discuss accommodation, but there was a Supreme Court case which established that Connecticut law requires accommodation as well. So these two laws are very similar. Connecticut's language is slightly different. It talks about physical impairment as opposed to disability. And therefore, as Sal previously stated, it's really not helpful to focus on whether this person actually has a disability or not. That used to be one of our defenses that we would bring. And it's still possible to bring that defense in a lawsuit. But if you're an employer and you're trying to work with someone who says they have a disability, often you'll get documentation from a physician to enter into when you're entering into the interactive process to determine how you're going to accommodate that. So we usually focus, and also given that Connecticut's definition is physical impairment, which is a slightly different standard from disability, we usually focus just on, okay, if this person has physical or mental limitations that are impacting their performance, we enter into the interactive process with them. Sal and I advise our clients on how to do that. And that is part of what we're discussing here today with regard to aging. So the ADA prohibits discrimination against qualified individuals with disabilities, requires employers to engage in the interactive process to consider whether the disabled employee can perform the essential functions of the job with or without a reasonable accommodation. Next slide, please. So here's some more statistics. In 1990, workers in the age category of 40 to 54 filed the majority of ADEA or DIA charges, and workers in the age cohort of 65 plus filed relatively few. Okay, that was in 1990. But by 2017, more charges were filed by workers in the age range of 55 to 64 than the younger age cohort. This is what I'm seeing in my practice, that the claims tend to come in this range. I would make it even higher and say probably what I'm seeing is sort of the 55 to 70 year cohort, and that's where the claims come in. By 2017, the percentage of charges filed by workers age 65 and older was double what it was in 1990. And part of this is reflective of the aging workforce. So the workforce is aging. More claims are being filed by people in the older cohort. And that is why we're dealing with this issue. Next slide, please. So here are some of the age discrimination claims that I've seen and that exist. Failure to hire or promote, mandatory retirement, suggesting or assuming someone's ready for retirement, denial of benefits based on age-based remarks, comments, jokes, and age-based testing requirements. Next slide, please. So there was a recent case filed against Yale New Haven Hospital in which it's alleged that Yale has a policy in which all physicians age 70 and older who apply for or renew privileges with Yale New Haven Hospital must undergo a neuropsychological exam and an eye medical exam, and younger workers do not need to take the same tests, okay? So this is, the allegations of the complaint are that this would be illegal because it's treating people differently solely on the basis of their age, 70 plus. So the question becomes, can an employer do that? And an employer best practices, not commenting specifically on the Yale case, I'm not involved and I don't know anything other than what's in the public record on this. But the fact of the matter is, it's a better practice not to have testing requirements based on age, but rather to have them either at intervals, every year, every 2 years. Everyone in a specific job category needs to be tested on specific things for business-related reasons, which is really the best way to proceed. And then you have everybody subject to the same standards and procedures. Next slide, please. So we're talking about the interplay between the Age Discrimination in Employment Act, the ADEA, and the Americans with Disability Act, the ADA. This is very important. The ADEA, the ADEA, the age discrimination law, does not require accommodation based on age. So here's a little footnote from our COVID days. The CDC had been noticing that there was a higher correlation between COVID, serious illness and death, and age. So there were some requests for accommodation in the workplace based on age because of that CDC notice. However, it's not required for employers to provide accommodation based on age. So if someone came to you and said, I'm 65, there's a higher correlation between COVID illness, serious illness, and death, and I want an accommodation as a result, you don't need to provide an accommodation based on someone's age. You do, however, need to provide an accommodation, or at least enter into the interactive process regarding an accommodation based on a disability. So, so the fact is that 65-year-old might have had a disability, but that wasn't the request. If they had a disability, that was the basis for the request, and you'd have to consider it. Okay, but this is clear. ADA does not require accommodation based on age, and it cannot, you as an employer cannot require testing or other kinds of job-related review based on age. The ADA requires employers to consider accommodations for disabilities. Age and disabilities do not necessarily correlate, but they might. And if they do, that's fine, but the focus is on the disability for an accommodation request. Treat the disability of an older person the same as you would for any other disabled employee. There's no differentiation. Next slide, please. So let's talk about fitness for duty testing. Generally, a disability-related injury or medical examination of an employee, or medical examination of an employee may be job-related and consistent with business necessity when an employer has a reasonable belief based on objective evidence that an employee's ability to perform essential job functions will be impaired by a medical condition, or an employee will pose a direct threat to due to a medical condition. Next slide. So sometimes the standard may be met when an employer knows about a particular employee's medical condition and has observed performance problems and reasonably can attribute the problems to the medical condition. An employer may also be given reliable information by a credible third party that an employee has a medical condition, or, for example, a supervisor, or the employer may observe symptoms indicating that an employee may have a medical condition that will impair their ability to perform essential job functions or will pose a direct threat. In these situations, it may be job-related and consistent with business necessity for an employer to make disability-related inquiries or require a medical exam. To Sal's earlier point, we don't want to assume somebody is disabled. You don't want to have a case where the employer is regarding an employee as disabled if there's no evidence to support that. But if there is evidence, and particularly in a situation where a person has raised the issue, then there may be the need for fitness for duty testing. Next slide, please. So this is an example of a situation in which, let's assume that the crane operator is over the age of 40, and he appears to become lightheaded, has to sit down abruptly, and seems to have difficulty catching his breath. His supervisor has observed this and reports it to HR. In response to a question from the supervisor about whether he is feeling all right, the crane operator says that this has happened to him a few times during the past several months, but he doesn't know why. What can the employer do? Next slide. In this case, the employer has a reasonable belief based on objective evidence that the employee will pose a direct threat to safety of himself and others because he's a crane operator. So the job does make a difference in many cases. And therefore, the employer may require the crane operator to have a medical examination to determine whether the symptoms he is experiencing make him unfit to perform his job. To ensure that it receives sufficient information to make this determination, the employer usually would provide the doctor who does the examination with a job description, including any physical qualification standards, and require that the employee provide documentation of his ability to work following the examination. Now, what usually happens in this case is that the physician the question is, can the employee do the job with or without a reasonable accommodation? Now, you don't have to accommodate, someone being sick on the job when they are operating, heavy machinery. So that would be an essential function of the job, that you have to be able to stay alert and remain able to perform the job. And that would be something that probably may not be able to be accommodated. So that's really where the question of the interactive process / fitness for duty coincide, and that decision is going to have to be made once there is a medical examination. Next slide. Here's another example. Several customers have complained that Richard, a customer service representative for a mail order company, has made numerous errors on their orders. They consistently have complained that Richard seems to have a problem hearing because he always asks them to repeat item numbers, colors, sizes, credit card numbers, and he frequently asks them to speak louder. Customers have also complained that he incorrectly reads back their addresses, even when they have enunciated clearly and spelled street names. Okay, so what can the employer do in this situation? In this case, the employer has a reasonable belief based on objective evidence that Richard's ability to correctly process mail orders will be impaired by a medical condition, i.e. his hearing. The employer, therefore, may make disability-related inquiries of Richard or require him to submit to a medical examination to determine whether he can perform the essential functions of the job. Again, this is a situation where you don't want to make assumptions, but if you have evidence that there may be something going on that's a medical condition that's prohibiting the person from performing the job, I think in this case, a reasonable discussion with Richard, to the extent of we're getting complaints from customers, there are errors on the forms, but we're getting complaints that it appears that you're not able to hear or that you're having some difficulty. Do you want to discuss this with us and see what is going on? Now, this is again an interesting kind of scenario because it is possible that the employer will have already disciplined Richard for this prior to getting any information from customers about why these errors are occurring. So it would be perfectly reasonable and within the employer's right to have disciplined Richard before it received any information from customers. if it received the information first that there might be a problem going on, then I think that could be tricky, and I think it's better to address the problem. It is only in the situations where you have no evidence of a disability or no information about a disability where you would proceed with documented performance management. But if you get the evidence of the disability beforehand, or the request for accommodation before discipline is issued, then you would need to enter into the interactive process to see if the employee can perform the essential functions of the job with or without a reasonable accommodation. And here, it may be an easy fix. There may be some kind of technology that can help Richard with his hearing if he's working on a telephone, and it may be low cost to the employer, and it may be something that the employer would have to implement in order for him to be able to do his job. Again, an interesting twist on this would be, what if the employer provides the accommodation and still errors are being made? Then yes, you can discipline him because he's given the accommodation requested, and there's still errors being made. And so, the employer doesn't have to continually guess why are errors being made if the requested accommodation has been provided. Okay, next slide, please. Okay, so if you've noticed an older employee is just slowing down in his productivity at work, what do you do? So some questions which would arise under the ADA also would be, how are you measuring productivity? Is this an objective standard? Is this business related? Or is this just an imposition of a stereotype that he seems to be getting slower? The facts are important. That's why when I have these conversations to advise clients about how to proceed, we want to know specifically what is going on. I had a situation where on a manufacturing floor, there was concern about an older employee who was having difficulty getting from one site to another. And there was objective observation of appearing to possibly trip, and possibly, but not quite trip, wobbly, walking, that kind of thing. That objective information on a busy manufacturing floor, first of all, that kind of impairment could cause an accident. So that would definitely be a risk. And that's why I'm saying the environment and the details of the situation are really critical. So in that case, I would say it would be appropriate and paramount for the supervisor to, talk with the employee about the observations. What happens if the employee refuses to engage in the interactive process? Can the employer send the person for a fit for duty test under those circumstances? Yes, if there's objective, observable physical limitations that are observed in the workplace that can cause safety issues, such as the crane operator, but it doesn't have to be it could be maybe less extreme than that. I mean, even just tripping and falling and hurting oneself, on a manufacturing floor could be grounds for that. But again, you have to treat everybody the same. So if you have a 20-year-old who's tripping over things on the manufacturing floor, I mean, first of all, you ask yourself, is there a problem with the manufacturing floor, and or why would this be happening? Or if you have people, you don't make this determination on the basis of age, you make it on the basis of the physical limitations or potential safety hazards that you are observing. Okay, so this is where the question of, is the same measurement applied to everyone? Is it an objective productivity standard? And or if it's an clearly objective productivity standard, this person's not, making as many widgets as the production requirements demand, and which is an essential function of the job. is that something that can be accommodated? If it needs a change in the essential function of the job, then you don't have to accommodate a change to the essential function of the job. You know, on the other hand, I've worked with employers, we have these rules, but many employers want to keep loyal long-term employees. And so then it becomes a question of, okay, well, while it may not be required under the law, is there something else that you might want to consider in terms of this person's role? Is there something they could do that would, be different and not require the same level of physical exertion? So there's a larger conversation that you can have in determining how you want to proceed. But again, none of this can be based on assumptions or stereotypes about age. They would be just that secondary consideration. If you want to go beyond what the law requires, is always something that you can consider. But this is just our aim today, is just to tell you what the law requires. Okay, I think we have another slide. Okay, so I sort of anticipated this slide in that if an older worker cannot perform all of the physical requirements of the job, what do you do? So as I stated earlier, the ADEA does not require you to accommodate someone on the basis of age, but it does require you to accommodate someone on the basis of disability. So if there's objective evidence that there are difficulties meeting the physical requirements of the job, you could address those with the employee and see if there's some kind of condition that they want to have, that they're requesting an accommodation for. And, normally in these situations, it is the worker who should come to the employee to address, to request the accommodation. But sometimes that may not be the case. And as long as it's objective evidence, as the previous examples have shown, then the employer would be within its right either to request a fitness for duty examination, or often when that happens, the employee will raise, well, I know I have a disability and I want an accommodation. So they may go hand in hand. Okay, next slide. Okay, here's another quick example of what I mentioned earlier, which is a potential memory issue. So you're noticing that an older employer is forgetting things and repeating himself. So the first question is this affecting job performance? And if so, how? Again, we need the objective documented evidence that it's impacting job performance. Only if it's impacting job performance should you have a discussion with the employee about it. And so that's the issue. The issue is it job related? Okay, next slide. Okay, so I got through it in 11 with 3 minutes to spare. Let me just check and see if we have any questions. Okay, it looks like on this particular issue with regard to aging in the workplace, I do not have any specific issues or questions, and I'll just double check the chat as well. Nope. Okay, so very good. So I think I'm hoping that between Sal's presentation and my presentation, you've gained deeper insight and appreciation for the complexity of ADA/aging issues and the importance of engaging in an interactive process when you see that there may be a disability involved and or when the person requests a reasonable accommodation. But on the flip side, you can also request a fitness for duty exam, and you can proceed with performance management if there is no ADA issue. And you should not, in any of these cases, make stereotypical assumptions or make assumptions or decisions based on stereotypes regarding a disability or age. And with that, I'm going to hand it off to Emily Souza for discussion of free speech in the workplace. I think maybe she has one minute to start. Okay, thanks.
We'll give it another 30 seconds or so, just in case people are joining at 11:50 on the dot. All right, it is 11:50. So good morning, everyone. My name is Emily McDonough Souza. I am an attorney in the Labor and Employment Practice Group, and I practice in Murtha Cullina's New Haven office. So as Tricia said, I am going to be talking with you all today about free speech in the workplace with a specific focus on a new law that was recently passed in Connecticut this past legislative session. It was signed into law in May of this year, and it went into effect on July 1st, 2022, and it has been referred to as the captive audience law. So what does this law actually entail? Well, it added new language to a statute that's actually already been in existence. General Statute Section 31-51Q, which many of you may already be familiar with, and we will be discussing that statute in more detail later on. But the new language itself that we're talking about prohibits employers from disciplining or discharging or even threatening to discipline or discharge employees for refusing to either A, attend meetings put on by an employer or the employer's agent, representative, or designee, where the employer's primary purpose is to communicate the employer's opinion concerning political or religious matters. And it also prohibits employers from disciplining or discharging employees for refusing to even listen to speech or even view communications from the employer that have a primary purpose of communicating the employer's opinion, again, with regard to religious or political matters. And the new statutory language creates a right for workers to sue individually under this statute for damages for engaging in conduct that is in violation of the law. And should an employer be found in violation of this law, the employees will now be entitled to the full amount of their gross lost wages or compensation, along with costs and reasonable attorney's fees. So basically, as a result, Connecticut employers are now required to accommodate a new and really substantial expansion of their employees' free speech rights in the workplace. Next slide, please. All right, so you might be asking yourself, what do the terms political matters mean or religious matters mean? You know, that could really be quite broad, and I would agree with you. As far as how these terms are defined within the statute, political matters means matters relating to elections for political office, political parties, legislation, regulation, and the decision to join or support any political party or political, civic, community, fraternal, or labor organization. So quite broad. And then as far as how religious matters are defined under this law, this refers to matters relating to religious affiliation and practice and the decision to join or support any religious organization or association. And we'll be talking more in a moment about how this law really came to be, how it was championed and shepherded into effect at the behest of the unions in the state, and was really driven by a primary concern about employers who were requiring employee attendance at meetings or presentations in which they were trying to convince the employees not to unionize. But it's important to note that, as we see here, the language of the statute is clearly not limited to the topic of unionization. It goes much further than that. Next slide. So here's a list of some things that are not prohibited under the law. As discussed, employers communicating any information that the employer is required by law to communicate to them, that is not prohibited under the law, but only to the extent of such legal requirement. Employers communicating any information that is necessary for employees to perform their job duties. Institutions of higher education who are meeting with or participating in any communications with employees that are part of their coursework, any symposia, or an academic program at such institution. It also does not prohibit casual conversation between employees or even an employee and an agent of the employer, provided that participation in such conversations is not required. So pretty tricky to navigate that there. You have to make sure that the casual conversation is indeed voluntary from the perspective of the employee. And then lastly, what is not prohibited under the law, a requirement to attend a meeting limited to the employer's managerial and supervisory employees. So as long as lower level staff is not required to attend such meetings, it is fine for managerial and supervisory employees only to be required to attend such meetings. Next slide, please. And then we have one group that is actually entirely exempted underneath this statute, and that is any religious corporation, entity, association, educational institution, or society that is exempt from the requirements of Title VII of the Civil Rights Act of 1964, or is exempt from the provisions of General Statutes 46A-81P, and that statute has to do with exempting certain religious entities with having to comply with certain sexual orientation related discrimination laws in the state. With respect to speech on religious matters to employees who perform work connected with the activities undertaken by such religious entity. So that umbrella of type of religious corporations or entities or associations are exempted from this new statutory language altogether. Next statute or slide. All right, so how did this law come into being? It's actually been a long road. So traditionally speaking, the term captive audience meetings refer to the standard practice among employers of meeting with employees during union organizing campaigns to express the employer's view on the possible negative effects that unionizing may have on the general workforce. Employers are allowed to discuss the election process, the collective bargaining process, and potential ramifications that a unionized workforce could have for the employer-employee relationship. These meetings can be mandatory and take place on company property during working hours when the employees are on the clock, at least traditionally speaking. We will get to this law. So in the 1948 case of Babcock versus Wilcox Company, the National Labor Relations Board held that the then newly amended National Labor Relations Act allowed employers to hold compulsory audience meetings. And in the 74 years since Babcock was decided, the NLRB has repeatedly found that these compulsory audience meetings, AKA captive audience meetings, are permissible, and as such, they have really become a powerful tool for employers. Now, versions of this 2022 Connecticut law have been floating for years in the state of Connecticut. And it is interesting to note that prior versions were actually deemed too legally flawed to proceed. In fact, just 4 years ago, the past Connecticut Attorney General opined that a bill with the exact same language as the statute that was passed in May was preempted by the NLRA, aka the National Labor Relations Act. But in 2019, the current Connecticut Attorney General acknowledged the possibility of a preemption challenge, but ultimately concluded that the bill is defensible, and if enacted, his office stands ready to defend it. So here we are today in 2022, and it has in fact gone into effect. And we will see how it will be defended as I will get into some legal challenges that have arisen. And, you know, I think it's important to note that with union organizing efforts at places like Amazon and Starbucks that have really been filling up headlines in recent years, this new law essentially makes it easier for unions to win organizing votes among employees. And on the other hand, there has been a large critical voice on the other side, on the business side of things, criticizing this new law as really being an example of how Connecticut is being hostile to businesses, as they argue, and pointing to other defeats and fights that they have faced in recent years, including minimum wage increases and paid family and medical leave. But really, ultimately, reactions to the law reflect this unending struggle between labor and business that dates all the way back to the passage in 1935 of the Wagner Act, which established the right of most workers to join unions, compelled employers to negotiate, and established the federal government as the arbiter of labor relations. And big business at the time did call it an unconstitutional intrusion into labor management relations, but the Supreme Court ultimately upheld the law's constitutionality in 1937. Fast forwarding 10 years into the future, in 1947, another important law came into being, and that was that the Taft-Hartley Act was passed by a Republican congressional majority. And what this did is it narrowed the definition of unfair labor practices and empowered businesses to argue against unionization so long as, quote, such expression contains no threat of reprisal or force or promise of benefit. And the law says that, which is still in effect today as Section 8A of the NLRA, the law says that, quote, the expressing of any views, argument, or opinion, or the dissemination thereof, whether in written, printed, graphic, or visual form, shall not constitute or be evidence of an unfair labor practice under any of the provisions of the subchapter, if such expression contains no threat of reprisal or force or promise of benefit. Next slide, please. So, excuse me, absent any further clarification at this point in time, employers are left to wonder what discussions of legislation or regulation will look like in the context of employer-sponsored meetings. So some examples of questions that we have currently, as the law has not yet been interpreted, or as far as our courts are concerned. Some questions we have are, when is speech, quote, primarily intended to convey the employer's opinion? How is that determined? Is the state legislation in conflict with the National Labor Relations Act? And does the NLRA preempt this new law? And by the way, for those of you who may not know, preemption in this context essentially prohibits states and municipalities from regulating activity that the NLRA protects, prohibits, or arguably protects or prohibits. And a subsection of another type of preemption is that it prohibits state and municipalities from regulating conduct that Congress intended to be unregulated because it has been left to be controlled by the free play of economic forces, which I know is a mouthful. But that has been the primary argument, as we will talk later on, with regard to legal challenges against this law and similar laws. Another question that is left open right now, does the law infringe upon the free speech rights of corporations? That has also been another argument that has been used in legal challenges to this type of law. And then finally, how broadly can political speech be construed? So an employer may now have to consider whether discussions involving its position on matters of, for example, public health measures such as abortion access, COVID-19 vaccine mandates, if these might fall within the definition of legislation, regulation, or political matters. And another emerging and common topic of conversation in the workplace, as I'm sure we all know, is the topic of diversity, equity, and inclusion. And like public health discussions, an employer may now have to consider whether DEI discussions and trainings fall within this really undefined scope of an employer-sponsored meeting with the primary purpose of communicating the employer's position on political matters. So under this law, I mean, theoretically speaking, an employee could refuse to participate in an employer-sponsored DEI discussion or training and claim that these meetings involve the employer's views on religious or political matters. So without precise definitions or the benefit from learning from the application of similar laws in other states, because the majority of those, as I will get into, have been struck down, it just remains very unclear where employees' First Amendment rights begin and end. Next slide. All right, so here are some of the legal challenges I have been referencing. So outside of Connecticut, There have been several challenges to similar laws and or guidance in recent years. More recently speaking, the NLRB General Counsel, Jennifer Abruzzo, who is in charge of prosecuting unfair labor practices in this country, issued a memorandum actually announcing that she will ask the NLRB to find that mandatory meetings in which employees are forced to listen to employer speech concerning the exercise of their statutory labor rights, which would include captive audience meetings, are unlawful. So her focus with the memo, if you look at it, seems to be on employer speech urging employees to reject union representation. So, more narrowly defined to that topic of unionization, not as broadly defined perhaps as to all political and religious matters. And the memo also states that she will urge the board to require employers to inform employees that their attendance at these captive audience meetings are purely voluntary. However, I will say that her memo was quickly challenged in a federal lawsuit that was filed in Texas this year, and the suit currently remains pending. So we shall see what happens with that. The next bullet point on this slide refers to 2008, the U.S. Chamber of Commerce financed a successful challenge to a California law that regulated employer communications with employees without expressly banning mandatory meetings. So in this case, which was called Chamber of Commerce of the U.S. versus Brown, the Supreme Court held that the California law that prohibited recipients of certain state grants from using that money to assist, promote, or deter union organizing was preempted by federal law. Next on the list, this is actually no longer in effect, but in 2010, Wisconsin passed a similar captive audience legislation, very similar to Connecticut's captive audience law. And then in that same year, the Metropolitan Milwaukee Association of Commerce sued Wisconsin in the U.S. District Court for the Eastern District of Wisconsin, and it claimed that, again, the NLRA preempted the Wisconsin statute, and it argued that the NLRA allowed captive audience meetings that the Wisconsin statute banned. So despite all these unsettled questions surrounding the Wisconsin law, Wisconsin ultimately did enter into an agreement with the business groups and agreed that the NLRA preempted the state captive audience statute and that it would no longer enforce the law to the extent that it prohibited captive audience speeches or meetings. And then last on this list, more recently, in 2020, the National Labor Relations Board sued the state of Oregon in federal court, seeking a declaratory judgment to invalidate its captive audience law. In its complaint, the NLRB again argued that the Oregon statute was preempted because it conflicted with the NLRB's exclusive control over union election proceedings. But ultimately, that case was dismissed last year in 2021. And it is, besides Connecticut, it is currently the only captive audience legislation in another state that is in effect today. But I will mention that there are no reported decisions to date that address the substantive preemption or First Amendment issues with regard to that Oregon law. So either employers are following it, or if violations are occurring, they're simply not being challenged. Next slide. All right, so all of this brings us to the lawsuit that was recently filed in federal court in the District of Connecticut, challenging the constitutionality of this new captive audience law. The lawsuit was filed very recently, November 1st, 2022, by the U.S. Chamber of Commerce, the Connecticut Business and Industry Association, which has been very outspoken about this law, and a bunch of other trade groups representing retailers and the like. And the plaintiffs contend in this lawsuit that the law, as other legal challenges have contended, that the law violates the constitutional guarantee of free speech, arguing that regulating employer speech on labor issues is a form of prohibited content-based discrimination, as well as a form of prohibited viewpoint-based discrimination, because it prevents employers from sharing true facts with employees about the cost of unionization, such employees such as employees need to pay dues for representation, unions' interference with employer-employee relationships, unions' prioritization of the collective over the individual employees, and the financial impacts on employers. And the plaintiffs also contend that the law is preempted by the National Labor Relations Act, specifically that Section 8C of the NLRA that I quoted from earlier. So in light of all of these legal challenges, where does that leave all of you today? Where does that leave our employers today as far as this law is concerned? Bottom line is that the implications of this new legislation do remain unclear, but employers subject to the law can take steps to reduce their liability. So we would recommend reviewing your policies regarding mandatory meetings and trainings, particularly ensuring that the policies do not require employee attendance or participation in meetings that may fall within the scope of the law. Employers should make sure that managers, supervisors, agents, and other designees are aware of the law's prohibitions. Although the law provides a carve out for the informal voluntary conversations that I had mentioned earlier, anyone acting on behalf of the employer and holding such meetings may run afoul of the law, and the employer may be found liable should a private action be instituted against them. And also, employers generally should just be more mindful of their communications with employees moving forward, particularly on hot button issues that concern political or religious matters. And because the law provides a private right of action for individual employees to enforce their rights, employees of all scale and size are at risk for litigation under the law. So very important to remember. And in the meantime, we will be keeping track of this lawsuit, and we will provide any updates on that Murtha employment blog that we've been referencing earlier today. Next slide, please. All right, so moving away slightly from that captive audience new legislation, I had mentioned earlier that this new statutory language was added to an existing statute providing free speech protections for employees against their employers, and that statute is 31-51Q. So the statute, which was passed in 1983, provides both public and private employees the right to sue their employer if the employer disciplines or terminates the employee because of his or her exercise of free speech rights under both the First Amendment to the US Constitution and the Connecticut State Constitution. But there are limits to the statute. Specifically, such protected speech must be on a matter of, quote, public concern, and must not substantially or materially interfere with the employee's bona fide job performance or working relationship with their employer. So what do we mean by on a matter of public concern? We're talking about when the speech in question relates to a matter of political, social, or other concern to the community. And specifically, if it implicates an official's dishonesty, other serious wrongdoing, or threats to health and safety, then the speech trumps the employer's right to control its own employees and policies. So, for example, an employer cannot fire an employee who campaigns for a political candidate disliked by the employer. But on the other hand, the employee cannot use the statute as leverage in a personal dispute with the employer or as an excuse for poor job performance. If the employee is only complaining about a personal matter, such as the terms or conditions of his or her employment, this is not considered a matter of public concern under the law. So in sum, employees have the right to speak out about matters of public concern, which would include writing articles or letters, social media posts, and the like, as long as their speech does not unduly interfere with the performance of their jobs. Next slide, please. All right, so our court's interpretation of this law, it's been around since 1983, as I mentioned before, but it has become a little clearer in recent years, particularly under the Connecticut Supreme Court's 2015 decision in, I believe it's pronounced Trust, we'll go with Trust, versus UBS Realty Investors. So this was a case involving the plaintiff, Richard Truss, the head of UBS's valuation unit. And what he essentially did was he, at least in his mind, he blew the whistle on what he perceived to be alleged securities law violations by the company. So what happened was he reported to his superior that there were errors made by the company in valuing properties in the company's private real estate investment funds. And he also communicated that he believed money should be returned to investors. UBS's compliance officer and a third-party auditor agreed that while there were valuation errors, it was not enough to return monies to investors. And the company did ultimately discharge trusts for what he later contended in his lawsuit was a form of retaliation for his free speech and whistleblowing activities. Ultimately, it worked its way up to the Connecticut Supreme Court, and the state's highest court rejected a rule that was previously articulated by the US Supreme Court in a 2006 case called Garcetti. And that case had held that when public employees make statements pursuant to their official duties, the First Amendment provides them no protection because they're essentially not speaking as citizens for First Amendment purposes. They're speaking pursuant to their official job. But in trust, the Connecticut High Court actually disagreed with Garcetti, saying that under our state constitution, employee speech made pursuant to official job duties on certain matters of significant public concern is protected from employer discipline in a public workplace. A quote from this decision can be found on this slide. The Supreme Court concluded, quote, under the state constitution, employee speech pursuant to official job duties on matters of significant public interest is protected from employer discipline in a public workplace, and 31-51Q extends the same protection to employee speech pursuant to official job duties in the private workplace. And by the way, an example of acting pursuant to job duties would be presenting a report to higher ups in an organization. So you are technically making that communication within the context of your official job duties. And Garcetti would have said, did say in the past that the US Constitution does not protect such speech happening pursuant to the official job duties, and trust disagreed with that. So this case is a good example of a state high court providing greater protection for free speech under its state constitution than the US Supreme Court did in interpreting the First Amendment of the US Constitution. Next slide, please. All right, so this is the last slide, and I just wanted to, on a related note, make you aware of another statute in Connecticut that I'm sure you're aware of. It's a statute that protects employees who disclose employers' illegal activities or unethical practices, AKA engages in what is referred to as whistleblowing. So the statute, as you can see on the slide, it provides that no employer shall discharge, discipline, or otherwise penalize any employee because, one, the employee or a person acting on behalf of the employee reports either verbally or in writing a violation or even a suspected violation of any state or federal law or regulation or any municipal ordinance or regulation to a public body. Number two, no employer shall discharge, discipline, or otherwise penalize any employee because the employee is requested by a public body to participate in an investigation, hearing, or inquiry held by that public body or a court action. And three, the employer shall not discharge, discipline, or otherwise penalize any employee because the employee reports a suspected incident of child abuse or neglect pursuant to specific enumerated statutory sections. And then also, I should mention that with specific regard to municipal employers, the statute provides that no municipal employer shall discharge, discipline, otherwise penalize an employee because the employee or a person acting on their behalf reports to a public body concerning the unethical practices, mismanaged, or abuse of authority by such employer. And the provisions of the subsection are not applicable per its terms when the employee knows that such report is false. So just another statute that employers should be aware of in the area of employee free speech in Connecticut. Next slide. All right, so we have about 2 minutes left. If anyone has any questions, I don't see anything so far in the Q&A. All right, we'll give it, I don't know, Trisha, I don't see any new questions, so is
Then
it
we
time
get
for
an early
lunch?
lunch break. Yeah, sure. So we will resume at 12:50 with pay transparency. I hope you all have a good lunch break. We'll see you back after lunch. Thanks.
Hi, Alyssa.
Hey, Sal.
Wait. We'll give it one more minute, I guess.
Sounds good.
Okay, looks like we're ready to go. Welcome back, everyone. Welcome back from lunch. Alyssa and I are here to discuss the recent pay transparency laws and pay equity laws, which pretty much everyone is facing these days. And we'll give you some ideas of the different types of legislation that's coming down the pike, and what you can do to make sure you're ready to address these things. So why don't we start out? Alyssa, I think you're starting out, right?
Yep. Okay. So hi, everyone. My name's Alyssa Ferrone. I'm an associate in Murtha Cullina's Labor and Employment Group, and I sit in the Stamford office. And as Sal said, we're going to discuss some pay transparency topics today. So just diving in, why is pay transparency important? Why are we talking about this? Why have you been hearing about this? I think the overarching goal for everybody, as you know, nationwide as a society, is aimed at reducing the gender and race wage gaps. So this is not news to anybody. Historically, women are paid less than men across industries in similar roles for similar work, and people of color are paid less than white workers. And because things like annual raises, bonuses are based off of annual salary, once an employee, you know, is underpaid to begin with, it becomes impossible to make up the deficit over a lifetime. So that perpetuates the wealth gap, and that's, you know, could be a whole nother webinar and topic. So if we could have the next slide, Eden. We've seen a big push towards pay transparency, culminating in the laws that we're going to talk about today. And there's some evidence that this has already started working. The latest data from the Census Bureau shows that median earnings of women are now up to 81% of those earned by men, and that the median earnings for Black workers are now up to about 80% of those earned by white workers. So, and we'll see that on the next slide. So this is huge progress from where we started before the push for pay transparency. It's important to note that other factors may be contributing to this progress as well, such as education and opportunities being available to minority groups, but progress nonetheless. And so that's what I would say is the big overarching goal of pay transparency and the benefits that we will glean as a society. But apart from those, there are immediate benefits for employers, and Sal's going to take us through those now.
Okay, next slide. Okay, and this was the source here for Alyssa's comment regarding the median earnings for Black workers, which is increased to 80% of those earned by white workers in 2022. Next slide, please. Okay, so we know it's the law. We know it's something that you're going to be required to do, which is be transparent in terms of compensation information and information that you need to provide in job postings and things like that. But is there a business case for it? Does it make sense from a business standpoint? Well, we think it does, right? So, for example, it's going to facilitate attraction and retention of employees. Excuse me. Particularly with attracting new employees and retaining them once they stay. Studies have shown that it promotes trust and fairness, and even results in boosting individual performance of employees once this information, this sort of information, is out in the open and available for them to see. Finally, you know, employees are sharing their salary information with coworkers anyway. I think that's always happened. I mean, employers used to try to prevent that from happening by having, I used to see policies that said that you agree not to discuss your salary with anyone else, and your compensation with anyone else. And first of all, it's questionable whether those were ever enforceable in the first place, but now it's clear that they're not. So people are doing it anyway. So you might as well be filling in the gaps to make sure that the information that people are sharing is accurate, okay, and complete. Next slide, please. Okay, so just talk about the history real quickly. As I mentioned, in terms of preventing coworkers from sharing comp information, company-wide salary, historically, company-wide salary information was not disclosed, okay? Workplace norms and even policies discouraged frank and open conversations about among employees about their salaries. I think people were talking about it, but again, it was more gossip than anything else, because you couldn't draw any conclusions from these anecdotal, disclosures. Lack of transparency made perceiving pay discrimination more difficult than other discrimination. So, and that's a fact under the, longstanding Civil Rights Act of 1964, which prohibits, among other things, gender discrimination, as well as the Equal Pay Act of 1963. I mean, people didn't have this information readily available to them. They had to base it on innuendo and gossip, and they were taking a real risk. People would take a real risk in advancing these claims. But now it's almost, in addition to this, the concept of disclosure and transparency, it's also inviting a dialogue. Now, there are aspects of that dialogue which we're going to touch on, which you may not be happy about, okay? And I think pose some real concerns, but I guess openness is the way to go on these topics. Next slide, please. Okay, so a few years back, there was a case before the Supreme Court, Ledbetter versus Goodyear Tire and Rubber, and I bring up this case not because it is necessarily what led to these pay transparency statutes, which are really more recent. I mean, the Ledbetter was quite a few years ago, but. So the problem in Ledbetter was Ms. Ledbetter tried to sue for pay discrimination, and she claimed that she was getting paid less than her male peers. The problem is it took Ms. Ledbetter a while to figure that out. She just didn't know. And so the reason that was given for the disparate pay was that because she came in at a lower pay many years earlier. Surprise, surprise, right? And the court ruled that the statute of limitations prevented her from raising it now because it had happened. The discrepancy or the disparity was started many years ago. Now, in response to this, Congress came out and enacted the Lilly Ledbetter Act, which sort of modified that ruling a little bit, making each instance of pay disparity a separate claim so that you wouldn't have to go back 20 years. But under those circumstances, the remedy is still somewhat limited. The better thing, and this is something I always tell clients anyway, the better thing is avoiding these problems in the first place. No one wants a lawsuit and no one wants to buy a lawsuit. And yeah, it's great that we would win a lawsuit, right? But let's prevent these things from happening because it's better for everyone. It's better for the employee, it's better for the employer, and it's better for business. Next slide. Okay, so you go, I think you can jump in, Alyssa.
Okay, great. So, right, as Sal was just saying, this is why we're seeing the push towards for individuals like Ms. Ledbetter, who unfortunately was kind of the test rabbit going through this process. So now several states have enacted some form of pay transparency or equal pay law. Some of these states require disclosure of ranges in job postings and advertisements, and some are geared more towards just freely allowing employees to discuss pay in the workplace. So we'll get into the nuances per state now, but and if I can have the next slide. Another important part about this to understand as employers is the ban on salary history inquiries. So Massachusetts was the first state to pass an equal pay law in 2018, which banned employers from inquiring about salary history before making a job offer. It also prevents retaliation against employees from freely discussing compensation, and then Connecticut and New York followed suit shortly thereafter. So we're going to dive into the nuances now. I'm going to begin with Massachusetts on the next slide. Okay, great. So the Equal Pay Act was implemented in 2018. Importantly, this applies to nearly all employers in Massachusetts, including state and municipal employers who have employees with a primary place of work in Massachusetts. So this includes employees who work remotely from another state in Massachusetts. So this is pretty widespread among Massachusetts employers. So as we discussed, it prevents inquiry into an applicant's salary history. There are some exceptions here. So where an employee voluntarily brings up their previous salary during the interview process, an employer is allowed to confirm that that information is correct later. And once an offer has been extended with compensation, then the employer is free to discuss previous salary as well at that point. But before an offer is made, employers cannot ask a candidate about their salary history. And another important thing to know about this is this extends not only from the employer, but to its agents. So you can't use a recruiter or a job placement service to then inquire about the salary history. So just keep that in mind. Additionally, employees are permitted to discuss salary with each other, and employers must provide equal pay for comparable work. And just a note on comparable work under the State Equal Pay Act, that is defined as work that requires a substantially similar skill, effort, and responsibility performed under similar working conditions. So this is broader than equal work standard for the federal Equal Pay Act, which, equal work is a tougher standard to meet for employees. So employers really need to pay attention to the wages paid across their staff to ensure compliance with the comparable work standard. So Massachusetts at this point has no requirement to post salary ranges in job postings. It's just those things that we just discussed. And employees and applicants have two routes to seek a remedy for an alleged violation. The employee can file a claim for violation in court, or they can file a complaint with the AG's office. Both of those have to be done within 3 years of the alleged violation. And importantly, employers are not required to make an internal complaint first to HR or to a manager first. So employers may not necessarily be made aware of violations before the claim is brought in a more formal proceeding. So that's interesting to know. And then on the next slide, we see that a violation occurs in a couple of situations. It occurs when the compensation decision is made, if someone is receiving less pay for comparable work. It applies when an employee becomes subject to the decision, or when the employee is affected by the application of the decision. So employers can be found liable for a violation multiple times for the same salary. So this includes every time that an employee gets a paycheck, as is a result of the Ledbetter case.
That's right. That's right. Sorry, Alyssa, I was chomping at the bit. I wanted to jump in. You saw me.
No, please jump in. Please jump in.
No. Yeah, so this third piece is really what really saves these claims. Now, like Alyssa said, each time wages are paid is considered a new violation. That's great. The problem is that's not great for employers. What I'm saying is that's great for employees seeking pay parity. The problem with it is that it's only going to affect one or a couple 2 years. It's not going to affect the losses incurred over the life over the employee's career. I'm sorry, Alyssa, I'm going to sit still and be quiet.
No, that's absolutely perfect. And I think this is a great place for you to jump in because that's all I have for Massachusetts.
Oh, is that okay? Okay, so let me talk. Next slide, please. Okay, so law passed in October 2021 in Connecticut requires all employers to disclose wage ranges or salary ranges for all vacant positions, not only to applicants, okay, for jobs and postings, but to current employees. Okay, so it applies to transfers and it applies to promotions. Next slide, please. Okay, basically, I said all employers, but and that's true. But what that really means is any employer with one or more employees. All right, you can't be an employer without an employee. And it applies to any employer who is soliciting employees to work, even if these employees are working remotely from another state. And I'm glad to see that these statutes are starting to address remote work, because it becomes very difficult sometimes to figure out whether or not, if you have an employee working in, I don't know, in Michigan, working from home and is working remotely, whether or not these statutes, these laws are going to apply. So I'm glad to see that the legislature is starting to address that. Next slide, please. Okay, so what are we talking about when we talk about wage range or posting wage ranges? So somebody posted a question, asked me a question a few moments ago in the Q&A, saying, look, is it sufficient to say if we're posting for a job, something along the lines of $50,000 plus, for example? And the answer to that is no. You need to state a range. Okay, and it could include reference to any applicable pay scale. You could rely on previously determined ranges of wages for the position. You can use actual range of wages for employees who are currently holding similar or comparable positions, and you can consider the budgeted amount in arriving at this range. So next slide, please. Again, in Connecticut, similar to what Alyssa was talking about with respect to Massachusetts, employers are prohibited from inquiring about applicants' salary history. Again, some people may not realize this, but it's that sort of thing. Salary history is sort of what perpetuates this lack of parity in salaries and wages. So employers now are basically required to figure it out for themselves in terms of how much they want to pay for a particular position, and not, they're not going to score any points asking an employee how much they made in their last position, and now they'll just save the company money by paying them that lower salary. That's not going to fly. So a civil action is available under the law, and there's a 2-year statute of limitations. Compensatory damages for pain and suffering are available, punitive damages, as well as attorney's fees and costs. So you will see claims brought here. Whenever you see that there's availability of attorney's fees and costs, you're going to have an attorney chasing after these claims, because even if at the end of the day there's a violation and maybe the employee's actual damages are like $1,000, the lawyer gets his or her attorney's fees, which are going to be multiple times that figure. Next slide. The equal pay law, as Alyssa was saying, that an employee alleging pay discrimination based on sex or gender needs to prove that the employer was paying employees of the opposite sex a lower wage for comparable work that requires comparable skill, effort, and responsibility under similar working conditions. in the states, the federal EPA law required the same work. And the problem with that is that no two jobs are exactly the same. There's always a way to find a difference, to back into a difference. Comparable is a better standard. It's and it really goes to enforcing or preventing pay disparity in the workplace. Next slide. New York City. Okay, so New York City has a law, recently enacted a law, that requires covered employers to provide a good faith salary range for any posting for a new job, promotion, or transfer opportunity for positions based in New York City. It covers remote jobs and part-time jobs. Next slide. So it applies to any employer that employs 4 or more employees, including the owner. I found that to be interesting because the New York City human rights law applies to 4 or more employees, but we used to make arguments all the time that owners weren't included in that count because who's going to fire them, right? But now New York City is making it explicit that at least with respect to this section, it includes owners, and it doesn't even require that all employees work in New York City. It's as long as there's at least 1 employee working in New York City, the law will apply. Next slide, please. All right, so what do we mean by good faith range? Well, I don't know if anyone read this like about 2 weeks ago or 3 weeks ago. I think it was Citibank had a system, an artificial intelligence sort of flaw, I think, that automatically sent out a job posting, and it listed the good faith salary range for the position being between $0 and $2 million. Okay. Needless to say, that wasn't really good faith, but it was a mistake. Obviously, they weren't trying to pass that off as a salary range. But so that's one extreme. Okay. It's basically the salary range that you believe, or the employer believes in sincerity, that at the time they are listing the ad, that they are willing to pay the successful applicant. They need to provide lower and upper estimates for the salary in those ads in New York City. Next slide. Posting requirements. Any written description for an available job, is what this applies to. It job fairs, promotion or transfer opportunities from within, that appears in any medium, internal bulletin board, newspaper, etc. Okay, next slide. Okay, so penalties. Anonymous complaints can be submitted to the New York City Commission on Human Rights. Employees who are found liable will have 30 days to provide redress, to correct the problem. I'm not entirely sure what that means, although it sounds to me like there's an easy way to solve this. I mean, within 30 days, I'm getting the sense that as long as you then reissue whatever ad it is with the required information, that you'll be in good shape. But if you fail to do it, you can be liable for up to $250,000. Applicants do not have the right to sue under the statute, okay? But they can file a claim, again, with the New York City Commission on Human Rights. They won't be entitled to recover really anything other than it'll require the employer to correct the problem within 30 days. And thankfully for employees, or applicants rather, those reports can be done anonymously. Okay, so that they aren't, their names aren't disclosed, and then they don't end up getting the job anyway. They're retaliated against. Next slide. Okay, Westchester County, November 2022. Westchester County, which has been doing this for the last few years, has been following New York City's lead on statutes virtually identical. Okay, it's virtually identical. It requires employers to post salary ranges for any job to be performed in whole or in part in Westchester County. So next slide. See what I mean? I'm not kidding you when I say it's exactly the same. Employers with at least 4 employees located in Westchester County. Independent contractors are not included in reaching that threshold. Violations and penalties of up to $250,000 are available. Next slide. Now, New York State has some legislation pending. Okay, it needs to be signed by the governor, and when she does sign it, it will go into effect 270 days later. I'm actually very surprised this hasn't been signed yet. I thought that following the gubernatorial election in New York last month, I thought that this would be something that would immediately be signed. I thought it would be signed before, but it wasn't, and I'm surprised it hasn't. But it's going to require employers with 4 or more employees to disclose compensation, okay, or a range of compensation to applicants and employees upon posting an employment opportunity for a job that's going to be performed in New York State. If we're dealing with a commission-only position, New York State says basically all you need to say is that the compensation is based on a commission, and obviously there's no way you can put a range on that. So that's a much significantly less burden. Next slide, please. Okay, that's the minimum and maximum annual salary information needs to be provided under the New York State law. Next slide. Okay, any complaints will be handled by the New York State Department of Labor, which would result in $1,000 for a first violation, $2,000 for second violation, and $3,000 for third and subsequent violations. Next slide. Okay, so state law in New York already prohibits employer inquiries into salary history during the hiring process, and prohibits employers from banning employee discussions of pay at work. So that's statute that's already been in effect for a few years. Next slide. All right, salary strategies for compliance. You're gone are the days where you could be loosey-goosey about this, right? You're going to need to start the process of figuring out how much you're going to pay for a position by conducting an internal pay audit to ensure consistency. You absolutely want to make sure that your current situation doesn't reflect an EPA or race-based pay disparity. Document when you do start coming up with your range, document those factors, those objective factors that led to your decision. It's very, very important that you have it documented so that later on, if there is a challenge, you can point to the fact that you actually did consider certain objective factors in creating the ranges. Managers, recruiters, and HR professionals need to understand their obligations when creating job postings and hirings. We can't rely on templates anymore. We need new templates now, which has basically a line that provides the salary range. So it's important that you all and they understand their obligations in this respect. Next slide, please. Okay, prepare and train managers to address inquiries from current employees about salary disclosures that may not be in line with what they are getting paid. This I see as being the biggest challenge these salary transparency laws are going to pose. Not so much in recruiting, but now it's a situation where current employees are going to see these salary ranges and wonder, hey, why aren't I getting paid what these people are getting paid? Okay, so really, aside from being a legal issue, it really is an HR issue. It's a morale issue, and you need your managers and supervisors need to understand how to address these inquiries from current employees. A lot of people say that the effect of these laws will result in not in salaries increasing just across the board for everyone, but it will certainly increase, hopefully, for women and persons of color, and it might actually lower the salary, the comp for men, simply because now that it has, now that we need parity across the board, it's going to need to sort of equal out. It's important that in conducting your pay audits, that you look at the job classifications and you analyze the distinctions between different jobs. And if you do have people making, a certain amount, current employees making a certain amount annually, but you're looking to pay more for a new employee for the same position, come up with an explanation that you could, a documented explanation as to why you would be doing that. Now, I could think of one, which would be inflation. Okay, people are looking for more money these days, so these are things that you really need to consider. Not only the effect on recruitment, but on the effect of your current workforce. Next slide. Okay, so Trish Riley is next, and I'm running over, of course. Right. I don't know. Did you see any questions here?
There was a question, and I know we're over, so I'll just briefly say that there was some questions as to whether they have to disclose the whole benefits package. And so far, it's just the base salary. Now, there is, it's your bonuses are a large part of the compensation. I think it's a good idea to preemptively do that. And this is also why it's important to connect with us on LinkedIn and subscribe to our blog, because as we get more guidance on this, we'll be updating it regularly and posting regularly. So you'll be the first to know once more guidance is issued.
That's right. That's right. Thanks, Alyssa.
Great. Thanks,
All right,
Alyssa.
Tricia.
Thanks, Sal.
All you.
All right. Thanks very much. Okay, good afternoon, everyone. I am hoping that this is review for most of you on the call today, because we've been through a year of this, right? And so I have to say that I haven't, in the beginning, I think there were some rocky starts, but I think more recently, employers and employees and the Paid Family Medical Leave Act Authority have all sort of ironed out a lot of the, rocky parts. And so I think that we're doing pretty well with this, but I'm happy to, discuss any specific questions or issues that might arise, and I'll try to check the Q&A for those. Okay, next slide, please. So again, we're going to review the basics of the program. And I think one thing that we're going to review that maybe people are, struggling with on an ongoing basis is PFMLA's interaction with other leave laws. That's always a challenge, is the integration of leave laws. Discuss claim administration and employer obligations. I think most of you probably already understand and know that and have experience with it. And then potential legal issues. Again, I am pleased to report that for the most part, I'm not hearing at this stage in the game significant problems. And the fact that the authority has a very good website with facts, and they have established, as many of you may know, a small business hotline / telephone number. So that I found that was very helpful in the beginning. For smaller employers who needed guidance, they could get it directly from the authority. Next slide, please. Okay, so as we know, these changes were implemented last year as of January 1st, 2022, and it is a wage replacement program with caps. Next slide, please. So it is a paid leave benefit funded by employees via mandatory payroll deduction. And as Lori Letty mentioned in her update on Connecticut law, for those of you who participated in that section, of course, there are going to be increases to the deductions because they're tied to both the minimum wage, and they're tied to, the cap is tied to Social Security, the Social Security contribution base. And so there already has been, I believe, at least one increase, and we expect these to be, these will be ongoing in relation to changes both in the Social Security contribution base for the cap and for the increases in the minimum wage for the benefits. So the rate of the deduction is capped at 0.5%. And in 2021, the deduction applied to employees' wages up to, well, this would have been 2022, up to $142,800. And so for 2023, there is going to be an increase to the Social Security base, I believe around up to approximately 160,000, over 160,000. And that's going to change that's going to change the rate of deduction and the cap, and and then also with regard to the minimum wage change, that will impact the amount that is being contributed by employees as well. Next slide. So as I mentioned earlier, and as probably most of you know, it's the Connecticut Paid Leave Authority that is administering the Connecticut Paid Family Medical Leave Act. And as this indicates, the authority's website is very comprehensive. I particularly like the FAQs. I found those actually very helpful with regard to specific conditions. So during COVID, they had a lot of information about whether COVID itself qualified for PFMLA. I just noticed that there was a reference to monkeypox, or as now it's being called mpox. I haven't, so if you have that issue with any employer, any employees, that's another thing that is specifically addressed. The FAQs are very, very helpful. And again, if you're a small employer, there is a telephone number, there is a direct contact that you can make at the authority in order to help you. Next slide, please. So many of you have opted for the private plan route. And as you know, you can go the private plan route as long as it offers the same or better benefits as the public plan. And it cannot cost employees more than the public plan contribution of 0.5% of the Social Security base. And then it must demonstrate, the organization must demonstrate the ability to administer claims and benefits, and there's a bond posting requirement. I will say that there has been some criticism about there's been an observation / criticism that in fact, the way the legislation works right now, private plans are actually being supplemented to some extent by state funds, to the extent that they are deducting contributions from what would otherwise be a benefit. And so they're getting basically they're getting a financial benefit out of that. There was an op-ed recently in the Connecticut Law Tribune on that. I don't know if there's any current pending legislation to address that problem, but I'll keep my eyes open, and if so, I will do a blog post and/or send an update to this group to let you know, because but at this point, I haven't seen any legislation specifically. Certainly, there's been no legislation passed that is addressing that issue, if in fact it is a bigger problem or an ongoing problem. Okay, next slide, please. So as you know, that the Connecticut Paid Family Leave applies to employers who have one or more employees working in Connecticut. So the threshold is one employee. It does apply to sole proprietors and self-employed individuals who opt in, but they must remain in the plan for at least 3 years. And as with all of our statutes, there are some exceptions, and it does not apply to municipalities unless they have a covered public employee, which we'll get to. It does not apply to local or regional boards of education, again, unless they're public, covered public employees. And it does not apply to non-public elementary or secondary schools. And that's actually consistent, for those of you who don't know, with our FMLA law. Connecticut FMLA does not apply to non-public elementary or secondary schools. Now, covered public employees are unionized employees collectively bargaining to be included, and thereby including both unionized and non-unionized employees. Next slide, please. So this was effective as of January 1st, 2022. An employee, it's still true that employee must work in Connecticut and have earned wages of at least $2,325 in the base period and be employed by a covered employer. There is no hour or length of service requirement for PFMLA, as we know, and therefore an employee might reach that wage threshold by combining income from multiple employers. Just a note with regard to employees who may work for multiple employers. There is a notice on the authority website right now indicating that some employees may have overpaid, and if they work for more than one employer. So that's just something where there is information on the website. If an employee raises that with you, you can point them to the website. And just another note, what I really do like about the system is that it is incumbent on the employee to initiate the process. And we'll get to that later, but I find that it takes some of the burden off of the employer for administering this benefit. So there are 5 categories of employees that are specifically excluded from coverage. Next slide, please. The basic rule is that if the employee is subject to Connecticut unemployment insurance, then they are working within the state. If they're not subject to Connecticut unemployment insurance, then if the services are localized, performed entirely within Connecticut, then the employee will be considered working in Connecticut. Okay. If the services are not localized, if the base of operations is in Connecticut and some of the services are performed within Connecticut, then the employee will be considered to be working in Connecticut. If the work is not localized and there is no base of operations in Connecticut, or no base of operations, if the employee performs some of the services within Connecticut and receives direction and control from Connecticut, then the employee will be considered to be working in Connecticut. And if and only if there is no place of direction and control, no localized services, and no base of operation, if the employee resides in Connecticut, then the employee will be considered to be working in Connecticut. Okay, so this was a lot of information about, are they considered to be working in Connecticut? And obviously in our remote environment, this is an analysis that you are going to have to make. In addition, the analysis of whether an employee is considered a remote employee and subject to Connecticut laws, and or whether remote employees are subject to other state laws, depending on where they are located, is a very detailed analysis that applies not just to PFMLA, but to many benefits. And so I've been doing that analysis for a number of different employers who are deciding whether or not they want to make a position, for example, remote nationally, so that somebody could work anywhere in the country, but if the base of operations is in Connecticut. But there are very detailed rules and regulations depending on where the person works. So I just raised that now because if you have an issue where you are not sure if an employee is working in Connecticut and subject to paid family medical leave, the issue is likely larger than just whether they're subject to PFMLA. There's going to be a lot of different moving parts that are beyond the scope of this slide. So I'm happy to help you if you find yourself in that situation. Bottom line, if they're in Connecticut, that's easy. They're subject to PFMLA. But if they're working elsewhere, there's a detailed analysis that applies not just to PFMLA, but to other benefits, other regulations, other issues, and they may be subject to regulation in the other state as well. So that's just a footnote to say, I don't expect you to do this analysis on your own. It's just an example of the complexity of it when we're talking about a remote work environment. Next slide, please. So this is an important point, and I think most employers do understand this now, that PFMLA does not provide any job protection. And so what does this mean? This means that it's available immediately if the person has reached that 2,300 something wage threshold. So somebody could conceivably come into your workplace in the first 4 hours of working for you, say, I feel so sick and I have to take PFMLA. Okay. Now, if that happens, you know, and they've only been there for 4 hours and they're not saying that they have a disability that needs to be accommodated or something, but it happens immediately, you still have to look at other things. But if the only thing that is applying is PFMLA, then there is no job protection associated with PFMLA, meaning you can fill their position. Okay. So, so let's look at this chart. The federal, so PFMLA in and of itself does not require job protection. So what is the threshold under Connecticut law that triggers job protection? The threshold under Connecticut law that triggers job protection is 3 months. So the Connecticut Family Leave Act, which is the unpaid Connecticut Family Leave Act, used to be 16 weeks. You may recall, used to be 1 month, 1 year before applicability. That has changed. That changed in January of this year, along with the implementation of paid family medical leave. So the issue now is you have an employee who's been there for less than 3 months. You don't have to hold their job open under PFMLA. Now, again, like I said, that might beg the question about whether they're entitled to an ADA leave of absence. That's a different issue, but certainly under PFMLA, they are not required. You are not required to hold the job open. But if you hit the 3 month mark, you know, and they go out on 3 months and 1 day, then you've got a situation where you have them under PFMLA along with protected Connecticut Family Leave Act. That's where the job security comes into play. And then you have to send your Connecticut FMLA notification out and start counting the days off, so that if they can't return after their 3 months under Connecticut FMLA law, under FMLA law in general, they can't return upon completion of their FMLA, then you have no obligation under the FMLA to hold their job open. Okay. So I hope I made that clear. Under PFMLA alone, no job protection until you hit the 3 month mark. Then we are under Connecticut unpaid FMLA, which does require job protection. If they can't return after the 12 months, I hope, rather the 12 weeks. I hope I spoke properly on that. If they can't return under the 12 weeks under Connecticut unpaid FMLA, that's where, if they can return, you have job protection. If they cannot return, then there would be no requirement for job protection. But again, when I discuss this with employers, I also discuss it in the specific context of whether the person has a disability that's required to be accommodated with an additional leave beyond FMLA. That's a nuanced and fact-specific question. But the state of the law is PFMLA, no job requirement, no job protection. FMLA, which kicks in at 3 months, job protection for them to return at the 12-week mark after the expiration. Yes, you run these things concurrently. So if you have an employee who's been there for 4 months, you would run them concurrently, FMLA and PFMLA. And now because it's 4 months, the FMLA, Connecticut FMLA, requires you hold the job open for those 12 weeks until and then see what happens at the end of the 12 weeks. They're required to return. Okay. So I hope I made that clear. I'm finding that federal FMLA is the least relevant in Connecticut right now, because it still doesn't apply until an employee has worked at least 1,250 hours in the 12 months immediately preceding the requested leave. And of course, just as in the previous iteration of Connecticut Family Medical Leave Act, you run federal FMLA and Connecticut FMLA concurrently. So it's usually the situation that there's not going to be a lot of applicability with regard to federal FMLA. It's really Connecticut FMLA that's going to be more on your radar because it kicks in earlier in terms of the employee's time at work. Okay, next slide. Okay, so although this is run through the Department of Labor in terms of a deduction and a tax on a payroll tax, essentially, it is a non-charge event. It creates a non-charge against an employer's unemployment tax experience rate. So this, if someone takes FMLA, paid FMLA, it does not count against your experience rating as an employer. It does not increase the amount of contribution that you might have to make to unemployment insurance. That is a separate issue. Okay. Next slide, please. Okay. So again, now we're talking about the length of leave, which is, this reiterates pretty much what I was just saying, that federal FMLA allows an employee to take up to 12 weeks in a 12-month period. And except that employees can take up to 26 weeks in a 12-month period for military caregiver. Okay, military caregiver leave is always an exception here. Connecticut job protected leave allows 12 weeks in a 12-month period. All right, so the old rule that some of you might be familiar with was 16 weeks and 26 weeks, 16 weeks in a 20, and I believe a 2-year period. And now it's changed to be the same amount of time as federal. So as of January 1st, 2022, Connecticut FMLA unpaid is an employee can take up to 12 weeks in a 12-month period. And then again, there are caregiver leave exceptions, additional time off for that. But note also, which many of you already know, is that under Connecticut unpaid family leave, there is also the opportunity for an employee to take up to 12 days out of the 12 weeks for family violence leave. Okay, so Lori Letty mentioned previously that victims of domestic violence are now a protected class under Connecticut law. Note also, under family leave, victims of domestic violence have the right to use family violence leave under FMLA. And they can also take an additional 2 weeks for pregnancy. Okay. So, oh, sorry, it's right here, right? It was previously 16 weeks in a 24-month period, right? Okay, so then paid FMLA is also has the opportunity for 12 weeks for family violence leave and additional 2 weeks of income replacement for incapacity due to pregnancy. So Connecticut paid and unpaid are consistent in that regard. Next slide, please. So there also was implemented a change in covered family members under Connecticut's new law. So under FMLA, federal FMLA, a family member is still defined as a parent, spouse, or child who is under 18 or who is over 18 and has a disability. And under Connecticut law, the new change as of January 1st, 2022, expands the family member definition. It includes spouse, child, parent, including in-laws, grandparent, grandchild, sibling, and any other any other blood relative or close association equivalent to family. Okay, so if you have a PFMLA situation, you don't need to make this determination. It's the authority will make it for you. If you have somebody who's saying they're entitled to it because of this definition of family, you just say, okay, apply for it. And so therefore you can rely on the authorities determination on that if you then run your own FMLA accordingly. If you run it concurrently with PFMLA, if it's a case where the employee has worked there for more than 3 months, then you can apply it, and you don't really need to get into too much sticky detail about whether the person is a close association equivalent to family. But if you want to ask a few questions about it to ensure, if it's for PFMLA, let the authority handle it. If it's unpaid PFMLA, rather unpaid FMLA, then, you know, it's fair to ask a few questions about why they consider to be close association. But again, you can rely on the authority's conclusion in that regard. Next slide, please. So here's the definition, which is very detailed. And so this is the kind of thing that if someone comes to you and tells you this is the relationship, then it would count as a family member. It's a person with whom the employee has a significant personal bond that is like a family relationship, regardless of biological or legal relationship. And the statute itself gives specific examples. I don't think I'll go through these in great detail, but some of them they might be a little bit surprising to some of you, but a person with whom the employee lived for several years and considers to be family, sharing financial responsibilities of the household and one another's common welfare, even if they don't have any other kind of relationship. But in that case, they would be living in the same household and operating as family. Another example, a child of an employee's former partner who lived with the employee for several years and maintains a parent-like relationship. So in that case, it doesn't even require that child live currently with the employee. So there's a lot of exploration here for, you know, what would count and what wouldn't. And so you can get this information online, or, you know, you'll have our slides. So you can always refer to that. Next slide, please. Okay, so here we have the qualifying reasons for PFMLA. It is birth of a child of the employee or placement of a child with the employee for adoption or foster care. That's bonding leave. Need to care for a family member with a serious health condition. That's caregiver leave. And again, that's where that family member definition is extremely broad, right? So you need to refer back to that if we're talking about the caregiver leave. Employee's own serious health condition, including serving as an organ or bone marrow donor or pregnancy. Qualifying exigency related to employee's spouse, son, daughter, or parent being on active duty or having been notified of impending call or order to active duty. So that's the military leave. And then family violence, which we mentioned, which it can be up to 12 days. And again, yeah, so up to 12 days per year. Next slide, please. So can employers request medical documentation? An employee who is seeking job protected leave under the Connecticut FMLA and or federal FMLA must apply to their employer and provide all required documentation, including the medical certification. Okay, so the answer for the unpaid medical leave, again, if you're running that concurrently with a PFMLA, or if you're just running it after they've taken a PFMLA, but in most situations, it's probably going to run concurrently, particularly if it's the 3-month mark is the delineation there. So post 3 months, you're going to run PFMLA with unpaid FMLA concurrently, and you want to track the unpaid FMLA because that is the statute that requires job protection, but only up to the 12-week period. If they cannot return after the 12 weeks, then the statutory protection is no longer applicable. Again, footnote, you might want to continue a leave of absence under certain circumstances, depending on whether they have a disability, how long they've been there, et cetera, whether you can continue leave of absence as a reasonable accommodation, which is a secondary part of the analysis. But the basic analysis is run your unpaid FMLA concurrently with the paid FMLA to ensure that you're counting the time that you have to hold the job open. Okay, so an individual who is seeking income replacement benefits under the Connecticut Paid Leave Program must apply to the Connecticut Paid Leave Authority and provide all required documentation. the Connecticut Paid Leave Authority will not share the medical records it receives with the employer. So that's fine. You just send out the FMLA certification if you're running FMLA concurrently with paid FMLA. I will say that generally speaking, this has not been an issue. I have heard occasionally of employees who just refuse to file for Connecticut paid family leave. And frankly, in that situation, you know, it's unusual because most people would want to do it because it's to their benefit. It may not be to the benefit of a high wage earner, particularly if they have short-term disability that applies anyway. So there are some exceptions, but for the lower wage workers who don't have any other benefits, most people understand it's in their best interest and they go ahead and they apply directly. And the employer's obligation is to give them the information about how to apply, and then they go ahead and do it. Okay, next slide. So how do employees access the paid leave benefits? It's on the authority website. And I'll just say that much because these slides are very dense. And again, you can get that information on the authority website, which at this point is quite comprehensive and up and running pretty smoothly as far as I can tell. Okay. Now, this is a challenge, right? Interaction with PTO, short-term disability, and long-term disability. This is a little tricky, and I think most employers have figured it out by now, but I think this is worth going over. Employers may require employees to use PTO prior to PFMLA, but employees must be allowed to keep at least 2 weeks of PTO. Okay, so what am I seeing? I'm seeing voluntary, because if you require, unless you have a really generous PTO policy and employees have accrued just substantial amounts of PTO such that holding 2 weeks back isn't going to be a big deal and they're still going to be able to use PTO and you want them to use PTO, then it might be to your benefit to require them to use PTO prior to using PFMLA. But know that the law requires the employee to allow requires the employer to allow the employee to keep up to 2 weeks of PTO. So that is going to be on the employer to track that and ensure that those obligations are being met, you know, if they're requiring somebody to use PTO. So there's that issue. And then paid family medical leave benefits and employer provided benefits can be paid simultaneously, provided that the total amount of wages does not exceed 100% of the employee's regular wages. Okay, so you know, if you have an STD policy and somebody's also eligible, if they're eligible for that and they're also eligible for PFMLA, then the way it's supposed to work is that the short-term disability benefits can supplement the PFMLA benefits. I think what the Law Tribune criticism was referencing that I was just mentioning earlier is that I'm not sure that all STD policies are operating that way. And it's possible that some of them are reducing the STD benefit as a result of PFMLA. So you might want to check your policy or check with your broker to see how that is being managed if your intention is to provide 100% to your employees. So generally, STD and LTD insurance policies require that state-provided paid leave benefits are utilized before an employee can qualify for benefits under the STD or LTD policy. Okay. But again, those of you who have private plan options will know how yours works. It is possible that you've received a discount on your premium as a result of the PFMLA. So to the extent that you as the employer might be getting some sort of benefit by reduced premiums, you know, that could work in your favor as well. Next slide, please. Okay, so here we have interaction with some other laws, which again, I've kind of referenced. We know federal FMLA, which again, I don't think that only applies to employers with 50 or more employees. PFMLA applies to employers with 1 employee. Connecticut FMLA still applies to, applies to one employee. The change was effective to make it consistent with paid family leave. So unpaid, paid family leave, significant changes, as we know, to that law in 2022. And this is why I'm saying that federal FMLA in Connecticut's become virtually irrelevant, in my opinion. Now, the ADA and the Connecticut equivalent may require leave as a reasonable accommodation. And this is where I'm saying that even though the law says under FMLA, unpaid FMLA, you only have to hold the job open for 12 weeks. And then if they cannot return at the end of that 12 weeks, you can terminate them under unpaid FMLA. But the issue is, should you consider a reasonable accommodation if they have a disability? So that is an analysis that's very difficult to make, and you have to think about it. Okay. The Federal and State Pregnancy Discrimination Act may also, in Connecticut, certainly requires an accommodation, and for incapacity due to pregnancy, most employers are providing leave for incapacity due to pregnancy, and also PFMLA would cover that, FMLA would cover that, okay? And then, of course, we have workers' comp, which most people know how workers' comp works, right? Okay, I'm not quite sure how many more slides I have, but I know I'm coming up against 2 o'clock mark, but let's go with the next slide, please. Okay, so these are just case studies indicating sort of which leave will apply and what do we have to think about. So if there's an employer with 100 employees working in Connecticut, and the employee has worked full-time for the employer for 10 years and has 4 weeks of accrued paid sick time and 2 weeks of accrued vacation, the employer has a policy of requiring employees to exhaust all available PTO except for 2 weeks, which is required under the PFMLA, right? And the employee injures his hand in a non-work related accident and needs to be out of work for 8 weeks. Is the employee eligible for job protected leave? Okay, so the answer is he's worked there for 10 years, so that's more than 3 months. So yes, job protected leave. And so is he eligible for PFMLA? Yes, if he hasn't exhausted it already, and he worked, if he's worked for 10 years, then he's going to meet the wage threshold of the 2,300 approximately amount that's necessary for PFMLA. Okay, here's a situation where once this employee who's worked there for 10 years, let's assume he can't return after 12 weeks, while the FMLA doesn't require that you hold the job open for him, you might want to under the ADA because he's a long-term employee. If he has a disability relating to his hand, that he might need a little bit more time off. Can you provide him with a leave? I think those are the really tricky situations, because if you've done the job without him, or the job duties have been getting done without him for the last 12 weeks, why can you accommodate a leave of absence for another 2 weeks? I think the issue is in the details of, how long is he asking for? What are the circumstances surrounding the situation? What can you do? Do you need to consider accommodating a disability under these circumstances? How are you going to proceed? Okay, next slide, please. Okay, so let's see if I got this right. So the employee is eligible for Connecticut FMLA, federal FMLA, and Connecticut PFMLA. So the way this chart has been organized, you could see that the Connecticut FMLA and the federal FMLA, which are job protected leaves, are running concurrently as they should be. The employer, and those are unpaid leaves, the employer is requiring the employee to use PTO prior to the Connecticut wage, the PFMLA applying. So this employee had to use several weeks of PTO prior to getting the benefit of the PFMLA. Okay. Okay. So, we're talking about the voluntary is different, right? So I have a question here about voluntary use. You don't have to, preserve 2 weeks if employees voluntarily use their PTO. So if an employee wants to voluntarily use their PTO, so that they, for example, they might want to use PTO to make up the difference between what they get under PFMLA and the PTO that they have available, as long as it's voluntary, you don't have to preserve the 2 weeks. It's only if you have a policy require them to use the PTO that you would have to let them maintain the 2 weeks of PTO. Also, if you want to have a policy where you say, no, we're not allowing PTO for PFMLA, use of PTO during PFMLA, we should discuss that, because it may be, you might have to adjust your handbook policies, et cetera, depending on what they currently say and how extensive and broad they are. Okay. All right, I'm over time, so I'm not going to be able to get through these additional case studies. I hope that this overview was mostly repetitive for most of you, and I hope that you've been having good experience in in offering PFMLA to your employees. Personally, I do think that it's been a helpful benefit for employees to have, and that is that is sort of what I wanted to talk about in terms of where we are in this. So thanks for going through the slides. We don't really need the upcoming dates because those were actually for last year. So this really was a review, and I'm going to hand it over now to Mel Aska for ERISA. Thanks very much.
Thanks, Tricia. And thank you all for being here at the seminar. This topic is basically recent developments in employee benefits law. And what we're going to be covering in the next hour will be selected topics that involve retirement plans and health and welfare and cafeteria plans. So the first slide, next slide, please. As we all know, inflation has increased recently. And of course, these inflationary increases have been reflected in the upward movement of retirement plan dollar limits moving from 2022 into 2023. So every year around October, the IRS announces what the new limits are going to be for the next year. And the IRS issued that announcement in this October. And this chart on this slide basically has an array of selected retirement plan dollar limits that that people are pretty conversant in most of the time. And so we've got these selected limits and their upward movements from 2022 to 2023. So first, on the first line, elective deferrals. Again, these are pre-tax or Roth elective deferrals that participants make to 401k or 403b plans, for example. Presently, people can defer up to $20,500 into their accounts for 2022, but inflation has driven that limit up to $22,500 for 2023. Similarly, the age 50 catch-up deferral limit, again, that's for people who are going to be who have reached or will be reaching age 50 by the end of the year. This year, those people could make an additional $6,500 worth of deferrals. Next year, they can make up to an additional $7,500 worth. So this year in 2022, if you qualify for both the normal elective deferral max and the age 50 max, you can defer up to $27,000 of your compensation into your, say, 401k account. Next year, with the higher limits for both kinds of deferrals, the combined maximum deferral for someone qualified to use both limits will be $30,000. So the next line is the annual, not the next slide, the next line, thank you. The next line on this slide is the annual compensation limit. That's the compensation that can be considered under a qualified plan or a 403b plan for different purposes. This year, the compensation cap is $305,000. Next year, and this is quite a significant jump, it's going to go up to $330,000, which is quite a lot. The next line talks about a similar jump in the comp cap for certain governmental plans. The next line is the comp cap or the cap in defined contribution annual additions. Now, annual additions under a defined contribution plan is the sum of employee contributions, employer contributions, and then the participants' allocable share of forfeitures. So this year in 2020, that sum of those three elements taken together as annual additions cannot exceed $61,000. Next year, the limit on annual additions jumps to $66,000. This year, the annual benefit limitation on the defined benefit pension plans is $245,000. Next year, it's going to jump to $265,000. Again, fairly significant jump. Moving to the highly compensated employee threshold on compensation. Now, remember that a person is a highly compensated employee in the current year if they're a more than 5% owner of the employer in the current or prior years, or if their compensation for the prior year equals or exceeds the HCE compensation threshold. So for 2022, the HCE compensation threshold is $135,000. Next year, that's going to jump to $150,000. Again, a fairly significant increase. Similarly, the key employee compensation threshold, which is important for top-heavy testing, is going to jump from $200,000 this year to $215,000 next year. Last but not least, the OSDI taxable wage base. This is a piece of the FICA taxes. FICA taxes have two pieces, the first being the Social Security or OSDI tax. That is a tax levied on comp or wages, FICA wages, up to the OASDI taxable wage base. This year, the OASDI taxable wage base is $147,000, and next year it's going to jump to $160,200. Again, another significant increase. Next slide, please. So what are the implications for retirement plan sponsors of these higher limits that are going to be in effect for 2023? Well, obviously, the higher limits on compensation, the defined contribution annual addition limit, and the defined benefit plan annual benefit limit could increase a plan's cash costs. So, for example, if I'm an employer and I have a profit sharing plan component to my plan, and I provide a fixed profit sharing contribution of 10% of considered compensation, and I have a band of employees that will be earning up to say between $305,000 and $330,000 in compensation for next year, and I keep my profit sharing contribution formula at 10%. Obviously, my plan costs are going to go up, so I might consider changing my formula so that I have a lesser percentage of considered comp being contributed to the plan to keep my cost constant. Similarly, the increases in the elective deferral and the catch-up deferral limits could increase matching contributions depending on the matching formula. So people who are able to defer more up to the applicable limits might be deferring more. And if the matching contribution formula is as generous in 2023 as it is in 2022, all things being equal, matching contribution costs would increase. The next point is it's important to communicate relevant 2023 plan limits to plan participants before the beginning of next calendar year. You don't need to go down into the weeds with them and talk about annual additions limitations and things like that. But for example, it would be important to tell participants, if you haven't already, that in next year, the dollar limitations on regular elective deferrals and on age 50 catch-up elective deferrals will increase. That'll give them some heads up so they can do some planning for their savings rate next year under their 401k or 403b plans, for example. Now, these new limit increases also have some possible impacts on non-discrimination and top-heavy testing. Now, in general, non-discrimination tests, which apply to qualified plans, et cetera, basically look at benefits delivered to the highly compensated employee group versus the non-highly compensated employee group. So if these limits are pushing up the income threshold for highly compensated employees, that's going to change the population of HCEs and also the population of NHCEs. Similarly, for top-heavy testing basically looks at whether a plan is favoring key employees versus non-key employees. And again, if the income threshold for determining who's a key employee is going up, then the population of key employees is going to change from this year to next, possibly. And also there would be a possible change in the population of non-key people. So those changes can possibly affect your non-discrimination and top-heavy testing results in 2023 versus your results under different parameters for 2022. So if you feel you may have some testing issues, then reach out to your third-party administrator or your actuary or your benefits consultant and perhaps ask them whether it would be worth having them run some pro forma tests now for 2023 to see what effect these new limits would have on your testing results for next year. Okay, let's go to the next slide, please. This is an entirely new topic. We're going to be talking here about retirement plan amendments. These are amendments which under current IRS timing rules would be due to be adopted no later than the end of the 2022 plan year. Okay, so for obviously, if you have a calendar plan year, you're looking at a December 31, 2022 plan amendment deadline. So the first category of plan amendments that would be due by the end of plan year 2022 would be amendments to reflect discretionary changes that plan sponsors have made in their plans. So retirement plans have to be amended by the end of plan year 2022 to reflect any discretionary changes that the plan sponsor has implemented in connection with the plan during plan year 2022. So what are discretionary changes? Those would be plan design changes. For example, I decide to add a hardship withdrawal provision to my plan. They also could include changes in plan administration that affect the plan document. So let's just say I, the plan sponsor, decide that I'm going to create a plan administration committee to run the plan for me. And therefore, that's going to be reflected in the plan document. Or there are certain collectively bargained changes that would have to be reflected in the plan document. Let's just say collective bargaining ended and the agreement calls for an increase in the level of employer matching contributions. Well, clearly that's going to have to be reflected in your plan document. So if any of these changes have occurred during your 2022 plan year, then you're going to have to amend your retirement plan document to bring that document up to speed with those design changes by the close of plan year 2022. Plan termination is another event that could drive a plan amendment that would have to be made by the end of plan year 2022. So if you have a retirement plan that's terminating during plan year 2022, the law rule on that is that your plan document has got to be amended to reflect all applicable legal requirements as of the plan termination date. So let's just say I have a calendar plan year 401k plan. I've decided I'm going to terminate it as of December 31 of 2022. I have to then make sure that I amend that plan document by the end of calendar 2022 to have the document reflect all applicable law changes that apply to my plan as of that plan termination date. The third category of amendments that may have to be done by the end of plan year 2022 are plan amendments to section 457B deferred compensation plans sponsored by tax exempt employers like hospitals or foundations, etc. Those plan documents must be amended if necessary by the end of plan year 2022 to reflect applicable provisions of the Secure Act. So for example, the new required minimum distribution rules that were part of the Secure Act. It's unclear whether the IRS is going to extend that deadline. It's had some chances to do so, and it's not taken up the banner on that. So it's probably unlikely that deadline is going to be extended by the IRS. So for example, if you are a tax exempt employer and you sponsor a calendar plan year 457 plan, and if you look at your document and you believe that the document needs to be tweaked to reflect the new required minimum distribution rules under the Secure Act, then you're going to have to adopt your plan amendment to reflect those requirements by the end of this month. And then last but not least, required amendment list amendments. Every year, the IRS issues guidance, typically in the form of an IRS notice. where it lists, it's called the required amendment list. And basically that IRS guidance in that RAL, required amendment list, basically sets forth the sets of legal changes, legal requirements that need to be reflected in plan sponsors' 401A or 403B plan documents. So, for example, the RAL list that the IRS issued in 2020 basically said, by the end of the second calendar year after the date of this RAL list issue date, plan sponsors who have to make these updates have to make them no later than the end of calendar 2022. So you need to look at this IRS notice 2020-83, see if any of those required amendments apply to your plan. And if to the extent any of them do, then you'll need to amend your plan document by the end of this month. This is not a plan year deadline, it's a hard calendar deadline. So you need to amend those documents by the end of this calendar month to reflect any required amendments that are identified in that required amendment list that the IRS issued back in notice 2020-83. Next slide, please. This concerns retirement plan amendments that have to be made by an extended deadline. This extended deadline can be as late as December 31, 2025 or later. Now, earlier this year, the IRS issued two pieces of guidance. The first was notice 2022-33 that was issued in August. And then the IRS followed up with another notice 2022-45, which it issued toward the end of September. And those two notices taken together extended from the end of plan year 2022 to December 31, 2025, with some later deadlines, even later deadlines for governmental plans, to amend retirement plans and IRAs to reflect the applicable provisions of 4 recent pieces of federal legislation affecting retirement plans. The first piece of legislation was the Secure Act, which was enacted back at the end of 2019. So all provisions of the Secure Act that apply are provisions that can be reflected in plan documents by these extended amendment dates. The second piece of legislation, whose provisions need to be reflected in plan documents if they apply, is the CARES Act. That was enacted in March of 2020 toward the beginning of the COVID-19 pandemic. And the CARES Act provisions that enjoy these extended plan amendment deadlines that's listed here is the Relief Act that was enacted toward the very end of 2019. And that was the provision that allowed for penalty-free disaster distributions. And then last but not least was the Minors Act, also enacted at the very end of 2019. That had provisions that lowered the minimum age for in-service distributions under qualified pension plans like defined benefit or money purchase pension plans from age 62 to age 59 and a half, and also under governmental 457 plans from 70 and a half to 59 and a half. So these pieces of legislation obviously clearly affect a great number of types of retirement plans. To the extent that these provisions are relevant to your plan, you have a pretty relaxed plan amendment deadline to get those applicable provisions worked into your plan documents. So again, for these changes, the deadline is December 31, 2025. It's based on the end of the 2025 calendar year, not the 2025 plan year. And then governmental plans have an even later extended due date. Now, the question is, do you want to go that far out in time to make these changes? Consider, for example, whether it may be advisable to make some changes now under the law as it exists now, so that you don't wait as long as these extended deadlines and perhaps forget to make these plan amendments. So it's something to consider, making these amendments sooner rather than later. Okay, in the next slide, I have a chart. Next slide, please. Okay, thank you. This is a chart that combines the retirement plan amendment due dates, and it basically collects the information from the previous 2 slides. So in the first column, we have the plan amendment category. So that basically identifies the piece of federal legislation that is the source of the requirements that have to be reflected in your plan document. The second column is the December 31, 2025 deadline, amendment deadline for non-governmental plans. And those non-governmental plans are tax qualified 401A plans, which of course include 401k plans, profit sharing plans, defined benefit plans, money purchase pension plans, ESOPs, etc. They also include 403B plans of tax exempt employers and then IRAs. In the third column, we have this further extended deadline, and further extended deadline means an amendment deadline later than December 31, 2025 for governmental plans. And the kinds of governmental plans that enjoy this further extended amendment deadline are tax qualified 401A plans, which would include grandfathered 401k plans, profit sharing plans, defined benefit plans, money purchase pension plans, etc. 403B plans of public schools, and then 457B governmental plans. And then the last column, we've got this unfortunate group of plans, the 457B plans for tax exempt employers that don't enjoy extended plan amendment deadlines. And their unextended deadline, as we mentioned in the previous slide, is the last day of the 2022 plan year. So this is, again, a place where all that information is collected. The notes in this chart, we don't need to belabor them now, but if you notice in the third column, the heading for the further extended deadline for governmental plans, I added an asterisk, and that's to explain how that further extended amendment deadline is calculated for governmental 401A and 403B plans on the one hand, or governmental 457B plans on the other. So why don't we move to the next slide? And we'll start talking about some IRS guidance that's fairly recent and noteworthy for some plan sponsors. This slide concerns the IRS expansion of its determination letter program to cover, for the very first time ever, individually designed 403B plans. Now, just a little bit of a refresher, there are basically two kinds of plan documents, retirement plan documents. The first is an individually designed plan document, which is essentially a document drafted by a plan sponsor's employee benefits attorney. It's a highly customized document, and it's not offered to the plan sponsor by, say, for example, a mutual fund house or a bank or an insurance company. It's something that's written for the employer by typically an outside benefits attorney. That's, like I said, very highly customized document. So that's one type of plan document. The other type of plan document is what's called a pre-approved plan document. And that's typically the kind of plan document that is offered in the marketplace by, pre-approved plan providers like mutual fund houses, banks, insurance companies, the Fidelities, the Vanguards of the world, for example. Now, on the qualified plan side of things, these are 401A plans, like a 401k plan or a profit sharing plan. If that kind of a plan is individually designed, the IRS has historically allowed plan sponsors of individually designed 401A qualified plans to come into the IRS and request a determination letter. And what that determination letter does is it tells the plan sponsor that in form, the individually designed plan document meets all applicable legal requirements. So again, typically those letters have been available to sponsors of individually designed 401A plans, but not until now to individually designed 403B plans. So last month, on November 7th, the IRS issued a notice 2022-40, which expanded the IRS's determination letter program for the first time ever to individually designed 403B plans. And so if the 403B plan sponsor wants to get a determination letter for its individually designed 403B plan, it can submit a determination letter application to the IRS, but it can only go into the IRS with that application on a staggered basis. And if you want your first determination letter from the IRS, when you can file your application for the letter, with the IRS depends on the plan sponsor's the EIN number and the last digit of it. So if you're the plan sponsor and your EIN ends in 1, 2, or 3, and you want a determination letter for your individually designed 403B document, you can submit a determination letter application to the IRS on, beginning on June 1st of next year. Then if your EIN starts in 4, 5, or 6, you have to wait until June 1st of 2024 to file your initial determination letter application. And then last but not least, if your EIN ends with 8, 9, or 0, you have to wait out until June 1st of 2025 to submit your application. Now, you don't have to submit an application. It's not required, but if you want to do so, this is the time when you would need to file your application for your initial determination letter on your plan. And then last but not least, beginning on June 1st of next year, if you're terminating your individually designed 403B plan, and if you would like the IRS to issue a determination letter telling you that as of your plan's termination date, it meets all applicable requirements, then you can file a determination letter application upon your plan's termination. And you don't have to be concerned with that submission schedule in the middle of the slide. You can, if you're in that category of plans, terminating plans, you can make your determination letter application to the IRS beginning on June 1st of next year. But typically you'll need to make that submission within 1 year after the plan termination. All right, next slide. The IRS has been pretty active with 403B plans fairly recently, and it also fairly recently just opened up its Cycle 2 opinion letter program for pre-approved 403B plan providers. Remember we said previously that there are basically 2 kinds of 403B plan documents: the individually designed plan documents, which can now go in and get their own determination letters. Well, the second type, which is the subject of this slide, are pre-approved 403B plan documents. And those are documents that pre-approved 403B plan providers like mutual fund houses, banks, insurance companies submit to the IRS in this cyclical opinion letter program and get the IRS's approval in the form of what's called an opinion letter, not a determination letter, but an opinion letter telling the pre-approved 403B plan document providers that their pre-approved plan meets applicable legal requirements. So the current cycle for this program, Cycle 2, began back in May, and it's going to end. It's going to end on May 1st of 2023. So what happens is all the banks and the mutual fund houses that want to offer a pre-approved 403B plan document to the marketplace will be filing their applications for opinion letters now and until May 1st of next year. And then the IRS will consider all the applications, and then basically on the same day, sometime after May 1st, 2023, the IRS will issue all of the opinion letters that it's going to issue. And then at the same time, the IRS typically announces the period during which employers have to adopt the newly approved, pre-approved plan documents. And it's generally a 2-year adoption period. And obviously it's too early now for that guidance to have come out, but be watching for that, because if you want to refresh your pre-approved plan document, or if you want to adopt for the first time a pre-approved 403B plan document and shift away from your current individually designed 403B plan document, you want to be watching these deadlines to understand what your window is for adopting a pre-approved Cycle 2 403B document. All right, next slide. Next slide, please. Okay, thank you. All right, there's been some recent guidance from the IRS that is giving a broad hint that in the future, employers are going to have less discretion over flexible discretionary matching contribution features under their 401k plans. There recently was a cycle of opinion letters for 403B for 401k plans, pardon me, where basically adopting employers had until July 31 of 2022 to adopt cycle 3 401k plan documents if they wanted to. And of course, those documents were in this cycle 3 of pre-approved 401k plans, the IRS allowed those plan documents to include what are called flexible discretionary matching contribution provisions, where basically those provisions were sort of loosey-goosey, and they basically said, well, the plan sponsor may but need not make discretionary matching contributions relating to employee elective deferrals, and the employer has discretion over whether to make the contributions, what the amount of the contributions could be, what deferrals would be matched, what the rate of match would be, what the matching computation period would be. So there's for that cycle of 401k plans, the IRS did not come down hard and require certain plan document provisions to reflect what this flexible discretionary matching contribution feature should look like. But instead of basically drilling down and requiring that level of specificity in the plan document, what the IRS did say to basically employers that are adopting these cycle 3 401k plans with the flexible discretionary matching contribution feature is that even though we're going to let you have your plan document be sort of loosey-goosey, we're going to make you make two kinds of communications where you get a little more specific about what you're doing year to year with your discretionary match. So the first set of communications has to go out from the employer before any of those discretionary matching contributions are made to the plan. And in this situation, the employer has got to give written instructions to the plan administrator, which sometimes is the employer itself, or to the plan's trustee, which describes how that discretionary matching contribution is going to be allocated to participants, for example, as a uniform percentage of elective deferrals or as a flat dollar amount. The communication also has to specify the computation periods to which the matching formula applies. And then last, if applicable, the communication has to describe each business location or employee classification that's subject to different matching contribution allocation formulas. Now, the second communication that the employer has to make is a communication to participants. And this is a communication that has to go out no later than within 60 days after making the last discretionary matching contribution for the plan year. The employer has to send a summary of the communications that it previously gave to the plan administrator or the trustee to the plan participant, so that essentially they know what their matching contribution was for that year, so that they're not in the dark. Next slide, please. Now, when the IRS issued guidance fairly recently about this cycle 2 opinion letter program for 403B plan providers, it kind of came down harder on what the plan document provisions have to be in a 403B plan document, a pre-approved 403B plan document that's going to have a discretionary matching contribution formula. So what the IRS is saying this time around is that if you're going to be offering a pre-approved 403B plan document to the marketplace, then that plan document, if it has a discretionary matching contribution formula provision, that plan document provision is going to have some detail in it that's required in the plan document. So the first detail in the plan document is that the matching computation period, of course, that's the period for which the amount of the matching contribution is calculated. So the plan document has to identify the matching contribution period, such as, for example, the payroll period or the plan year, in order to eliminate any ambiguity over the need for a true-up match at year end. Second, there has to be a provision in the plan document about the possible need for a true-up match at the end of the year, where the employer actually makes the matching contributions more often than the matching computation period. So if my matching computation period is the plan year, but I actually make my matching contributions every payroll period, there's a possibility that I'll have a true-up match requirement at the end of the year. So my plan document has to say that. And then last but not least, the plan document has to have a definite allocation formula for the discretionary match, such as a discretionary match shall be allocated to each participant at a uniform rate. For example, 100% of elective deferrals up to a uniform deferral percentage of compensation. And then there is still some discretion left to employers that have this kind of a discretionary matching contribution formula in their pre-approved 403B plan documents going forward. They will still have discretion over the matching contribution amount, the matching rate, for example, 50% of elective deferrals, and they'll still have discretion over the elective deferrals that are matched. For example, I'm not going to have my 50% matching rate apply to elective deferrals over 6% of compensation. Next slide, please. The IRS has been pretty actively issuing guidance to retirement plan sponsors, and we have another example here. In June of 2022, the IRS offered what it's a pre-examination compliance program. And basically, it's a pre-examination means pre-audit. So the way this starts off is the IRS will send a plan sponsor a letter that its plan was selected for an upcoming audit, an upcoming exam that the IRS is planning to do. But what this program says is that, we've picked your plan to audit either on a limited basis or a full-scale audit, but under this program, we're going to give you, the plan sponsor, a 90-day window to basically self-audit your plan. So you have 90 days to review your plan document and your plan operations to see whether they meet current tax law requirements. So employers go through that exercise. Next slide, please. Okay, so in that 90-day window, if the plan sponsor, having examined its plan document or in its plan operations, if it finds mistakes in its plan document or operational mistakes. So let's say it looks at its plan document, and it the plan document has a participant loan program, but a provision in that plan loan program that's written into the plan document just is defective when judged against the plan loan requirements under the tax code. So that's a plan document mistake. Or let's just say that the plan document looks great, but there's been an operational mistake. So let's just say it's a 401k plan that allows elective deferrals. And let's just say that the plan sponsor has found that in operation, it has incorrectly implemented deferral elections. So that's an operational mistake under a document that's good. So if a plan sponsor finds either plan document defects or operational mistakes, then under this program, the plan sponsor will be allowed to self-correct the mistakes by using the self-correction program, the SCP component of the IRS's Employee Plans Compliance Resolution System, or EPCRS program. Now, if the mistakes that are identified, the document mistakes or the operational mistakes, can't be corrected or self-corrected using EPCRS, then the plan sponsor can ask the IRS for a closing agreement, which would be basically the mechanism by which these mistakes get corrected, and you get your closing agreement, which is basically the blessing from the IRS that you've corrected everything properly. And so again, if you can't correct your mistakes using EPCRS, then you request a closing agreement from the IRS, and the IRS will then apply a fee structure that's currently in place under the voluntary correction program component of EPCRS, and have basically the plan sponsor pay that fee as a sanction. And of course, the plan sponsor has to correct its mistakes, pay that fee as a sanction. And the VCP fees are based on the amount of plan assets. So for example, if your plan assets are up to $500,000, your VCP fee, or in this case, the sanction for the closing agreement, is $1,500. If your plan assets range from over 500,000 to 10 million, the VCP fee, and in this case, the sanction, would be 3,000. And then if your plan assets are more than 10 million, the sanction would be $3,500. So if the IRS under this program, if it agrees with your conclusions and your self-corrections, the IRS will issue a closing letter. And if not, then the IRS is going to start either a limited or a full scope audit of your plan, which is what it started out to do, but gave you this pre-examination compliance program to try to get out of a limited or a full-blown audit. Next slide, please. All right, this has to do with the physical presence requirement and the IRS's COVID-19 era relief from that requirement. Just as background, IRS regulations require that certain signatures, for example, a spouse's signature on a consent to a retirement plan participant's waiver of a qualified joint and survivor annuity, must be witnessed in the physical presence of a plan representative or a notary public. Now, obviously, having that physical presence requirement in place during a pandemic is not a very good idea for obvious reasons. So during the COVID-19 pandemic, the IRS has over time provided temporary relief from this physical presence requirement. So the first relief the IRS issued was in early 2020, and it offered relief from this requirement through the end of calendar 2020. It's instead of a physical presence requirement, the IRS substituted certain electronic requirements that applied in lieu of the physical presence requirement. So the first bit of IRS relief from the physical presence requirement was given in early 2020 and extended to the end of calendar 2020. Then in early 2021, the IRS further extended the relief to the end of June of 2021. Then later in 2021, the IRS further extended the relief through June 30th of 2022. And then earlier this year, the IRS further extended the relief till the end of this calendar year, to the end of this month. Now, if the IRS doesn't offer additional relief, that physical presence requirement, which has been, lying dormant all this time during COVID, is going to spring back into place on January 1st. So that means, for example, if you have a plan that has a qualified joint and survivor annuity feature and your participant wants to waive that QJSA form and elect out of it to an alternate form of payment, that person's married, that person's spouse has got to provide consent, a written consent witnessed in the physical presence of a plan representative or notary public. It's possible that the IRS could further extend this relief, but it hasn't yet. So that's something to keep watch for between now and the end of the month. Next slide, please. Okay, we're going to switch now from the IRS to the Department of Labor. As I'm sure a lot of you know, the Department of Labor offers a program called the Voluntary Fiduciary Correction Program, or the VFC program. And what that program was last updated back in 2006. And what that program does is it identifies a certain relatively finite set of ERISA fiduciary breaches, and then gives guidance to plan sponsors who have committed those fiduciary breaches, or where other fiduciaries have committed the fiduciary breaches, and sets out a map of how to correct those breaches. And then there's a requirement, even though the program is called voluntary, if you want to get relief, if you want to basically have some relief that you've corrected the breaches and that there are no ERISA violations, you then file a VFC program application to the Department of Labor, giving them evidence of the breach and the correction of the breach. And then you wait for the IRS to review your VCP application and then to issue what's called a no action letter, meaning, okay, you've identified the breaches, your correction works, and we're not going to come after you civilly for civil penalties and other civil liabilities under ERISA for that breach. There's no self-correction allowed currently under the VFC program, which means you can't say, for example, your fiduciary breach is that you've made participant contributions to your plan late. You can't just sort of fix that now privately and not make an application to the Department of Labor and feel that you're relieved from possible ERISA civil liability. You really need to go in and get that no action letter. Well, recently, in November, the Department of Labor proposed an updated version of this VFC program, which for the very first time ever would allow plan sponsors to self-correct late deposits of participant contributions and late deposits of participant loan repayments if certain conditions are met. These are the two most frequently encountered ERISA fiduciary breaches. And so the Department of Labor basically figured it would be a good thing to allow sponsors to be allowed to self-correct. There's still a requirement that there be certain notifications under this new iteration of the program that be sent to the Department of Labor, but it's not really as formal as an application process. Now, this is just proposed guidance. It's not in effect yet. The DOL has requested comments due by January 20th of next year. And then the DOL will consider those comments and then issue the final guidance in the Federal Register when the new VFC program is available. Next slide, please. All right, the DOL, again, staying with the DOL, has also issued some final rules that govern when ERISA plan fiduciaries can consider environmental, social, and governance factors and when selecting investments and exercising shareholder rights. So on November 22nd of this year, the DOL issued a final rule under ERISA which clarified that plan fiduciaries may consider climate change and other ESG factors when they make investment decisions and exercise shareholder rights, including voting on shareholder resolutions and board resolutions. This final rule was published on December 1, and it will become effective on January 30th of next year. This new final rule overturns two previous final rules that were issued back in 2020. And those two rules essentially prohibited ERISA fiduciaries from considering ESG factors when making investment decisions in connection with ERISA plans. Basically, those two previous final rules required fiduciaries to consider only pecuniary factors when making investment decisions. Next slide, please. All right, now this new final rule, which is set to become effective next month, it does not change two important existing ERISA principles. The first is that the duties of prudence and loyalty require ERISA plan fiduciaries to focus on relevant risk return factors and not to subordinate participants and beneficiaries' interests, for example, by sacrificing investment rates of return or assuming additional investment risk to objectives that are unrelated to providing plan benefits. And then second, shareholder rights, including the right to vote proxies. Next slide, please. All right. So this new final rule, again, to be effective next month, changes the current final rule in important ways, including the following. The first is that the consideration of ESG factors is allowed. So a fiduciary's determination regarding an investment or an investment course of action has to be based on factors that the fiduciary reasonably determines are relevant to a risk return analysis, and these factors may include the economic effects of ESG factors on the particular investment or investment course of action. The second point is that these same standards about when ESG factors can be brought into play apply to when fiduciaries are making decisions about which qualified default investment alternatives to offer under their plan. And then the third point is this old tiebreaker test that's been replaced by a new standard that requires the fiduciary to prudently conclude that competing investments, including ESG investments, equally serve the plan's financial interests over the appropriate time horizon. So next slide. All right, now this is going to be some technical guidance. I think I'm going to skim over some of this in the interest of time, but it's just an important piece of guidance I don't want to ignore entirely. The IRS has recently extended the initial effective date of final required minimum distribution regulations. So we're back to IRS now. We've left the DOL for the time being, and we're back to the IRS. This notice 2022-53, which came out in October of this year, it basically provides that final required minimum distribution regulations under Code Section 401A9 are not going to apply any earlier than the 2023 distribution calendar year. And the reason this guidance came out in October was because the IRS had issued some proposed RMD regulations back in February of this year that had said that the final RMD regulations would apply a year earlier to 2022 and later distribution calendar years. Now, it is possible that the initial effective date of final RMD regulations might even be further postponed later than 2023 if Congress tinkers more with RMD rules. For example, the Secure Act 2.0, which is in the legislative hopper. That, for example, would change the required minimum distribution age from 72 to 75. So clearly, if that change is enacted in Congress, then IRS rules would need to reflect it by the effective date. So those are kinds of things that are swirling around now that may even further delay the initial effective date of final IRS RMD rules. So until the IRS does issue final RMD rules, plans and taxpayers can rely on the existing final regs, a good faith interpretation of the changes in the RMD rules that were made by the Secure Act back in 2019, effective as of 2020, and as set forth in the proposed RMD regulations that were issued in earlier this year. Now, I'm not going to go over the next, this is a pretty highly technical point, these next slides. So if we can skip these next 3 slides, but don't not pay attention to them. Maybe when you have a moment, go back and review them. But these slides concern IRS relief that has been granted to the 10-year RMD rule, which is a new post-death RMD distribution rule, which the Secure Act enacted. And it's basically, it essentially requires post-death RMDs made to designated beneficiaries to be made over a 10-year period. And sort of everyone or many people thought that the IRS would administer this 10-year payout period the way it currently administers the existing 5-year payout period, and would allow the 10-year distributions to be made no later than the end of the 10th year, but like right now under the 5-year rule, distributions can be delayed until the end of the 5th year of that period. But instead, the IRS for this 10-year rule has taken the position that distributions have to begin the year after the death and then be made over the 10-year period. So that took a lot of people by surprise. So the IRS has issued some fairly technical guidance, giving some limited relief to people who hadn't made initial RMDs in the earliest tranches of that 10-year period. So again, these are slides to review at your leisure. This next slide, this is our first slide that deals with health plans. We have, again, like we had the selected dollar limits for retirement plans at the beginning of the comments. Now we're dealing with dollar plan limits that concern health plans for 2023. So in this chart, the first line has to do with health FSA contributions. So again, health flexible spending accounts. Those are typically offered in connection with cafeteria plans. This year in 2022, the maximum health FSA contribution is $2,850. Next year, because of inflationary pressures, that amount is going to jump to $3,050. Also, the carryover maximum for health FAs is going to increase. Now, a health FSA, as probably most of you know, a health FSA can have either a carryover feature or it can have a grace period feature, but not both. So if you have a health FSA with a carryover feature, in 2022, the carryover maximum, which means the highest amount of unused dollars you can carry over from the end of 2022 into 2023 is $570. Next year, 2023, the carryover maximum dollar limit jumps to $610. So you can carry over from 2023 into 2024 up to $610 of unused HSA, health FSA dollars at the end of the 2023 year. The second category is HSA contributions. To be eligible to make HSA contributions, among other things, you have to be enrolled in a high deductible health plan, HDHP. And of course, your limits for HSA contributions depend on whether you are enrolled in self-only or family HDHP coverage. So this year, if you're enrolled in self-only HDHP coverage, your HSA contribution limit is capped at $3,650. Next year, if you're enrolled in HDHP self-only coverage, you can make up to $3,850 of HSA contributions. And then if you're enrolled in HDHP family coverage, this year you can make up to $7,300 of HSA contributions. If you're enrolled in HDHP family coverage next year, you can make up to $7,750 of HSA contributions. And of course, if you're 55 or older, this year you can make up to an additional $1,000 of HSA contributions. Next year, you can make another $1,000. So that limit hasn't changed. So then finally on this chart, looking at HDHP plans, to be a high deductible health plan, the plan has to have certain features. It has to meet certain parameters. One of those parameters is the maximum out-of-pocket cost. So for a self-only coverage under an HDHP, the maximum OOP for 2022 is $7,050. Next year, that jumps to $7,500. So if you have self-only HDHP, you have to put out $7,500 of your own funds before the HDHP coverage kicks in. Similarly, if you have family HDHP coverage, this year your maximum OOP was $14,100. Next year it's going to jump to $15,000. And then similarly, the minimum deductible parameter for HDHP coverage this year, if you have self-only HDHP coverage, your minimum deductible has to be $1,400. Next year it jumps to $1,500. And if you go to minimum deductible, if you have family HDHP coverage, your minimum deductible this year has to be at least $2,800. Next year it has to be at least $3,000. In the next few slides, if you move to the next slide, please. Next slide, please. Thank you. I won't belabor this. Actually, if you go back a slide, please. Okay, why don't you, yes, all right. I won't go through all of this in the interest of time, but basically there was a piece of federal legislation that was enacted at the end of 2020. It was called the Consolidated Appropriations Act of 2021. And it was basically a COVID-19 relief piece of legislation. And it offered certain kinds of reliefs to healthcare FSAs and dependent care FSAs, and allowed those kinds of FSAs to do things like expand their carryovers or their grace periods, or to basically extend coverage to dependents who age out, those sorts of things. So there was a lot of relief offered. It was all optional, okay? But there's a lot of relief offered to both health FSAs and dependent care FSAs. Now, if we go to the next slide, just one more slide down, please. Next slide. Okay. What's relevant, okay, thank you. What's relevant here is this bullet, cafeteria plan amendment deadline. So if you have a cafeteria plan and under that plan, you took advantage of some of these liberalized provisions for your health FSA or your dependent care FSA that were permitted to be used because of the Consolidated Appropriations Act, you have a certain plan amendment deadline to reflect those optional changes that you implemented into your cafeteria plan document. So for the plan amendment deadline is you've got to make your cafeteria plan amendments by the end of the first plan year following the plan year in which you implemented these optional changes. So for example, if you did implement optional changes for the first time in 2021, then you have until the end of the 2022 plan year to implement those changes. So there's the heads up on a cafeteria plan amendment deadline that may affect you. Next slide, please. And I'm not going to go into, next slide, please. Okay, thank you. This is another technical point. It has to do with the IRS recently doing two things. It fixed what's called the family glitch under the Affordable Care Act. And in connection with that fix, it added another cafeteria plan election change event. Basically, the ACA family glitch, it's a technical point, but it has to do with the affordability of employer-sponsored healthcare. And under the current rules, or the rules in effect before this glitch was fixed, was that for an employee's family member, the affordability of employer-sponsored group health plan coverage was basically based on the cost of self-only employee coverage under the group health plan. And so if that self-only employee coverage was deemed affordable under ACA standards, then it was deemed affordable not only for the him or her availability of exchange coverage to family members. So the glitch was fixed. That's the next slide. They are fixing the glitch. So the IRS fixed the glitch in final regulations that are going to become effective next week by basically determining affordability of employer-sponsored group health plan on the affordability of family coverage. So if family coverage is unaffordable, then covered employees, the covered employees' family members are basically eligible for this premium tax credit, and they can then go to the marketplace exchange, buy their insurance, and take advantage of the subsidy offered by the premium tax credit. So, and then the last slide is, so to allow those family members out from under employer-sponsored group health plan coverage so they can go out to an exchange and buy coverage and take advantage of the premium tax credit, the IRS also liberalized the election change rules under cafeteria plans in this notice 2022-41, and basically said that if coverage becomes unaffordable to these family members under this new fixed ACA rule, then the employee can, in the middle of the plan year, elect to drop the family members from employer-based group health plan coverage, and those members will be then free to go into the marketplace exchange, buy their exchange coverage, and then take advantage of the premium tax credit to make that coverage more affordable. So that's all I had. I think Dana's up next.
Hello. Yes, I am next. So welcome to the immigration update. My name is Dana Buchin. I am the chair of the immigration practice, and I'm going to fill you in as to updates in the almost post-COVID world. Okay. I'm not sure how to go to the next slide. Let me figure that part out.
Dana,
Okay.
just tell Eden next slide.
Okay, wonderful. So I-9 updates. As you remember, the purpose of the I-9 is to verify the employment eligibility of workers, irrespective of what nationality you believe them to be. All of them have to be run through the I-9 process within 72 hours of hire. It also serves you as a defense in case of an audit or investigation. So you have to absolutely make sure you have proper I-9 practices. If you don't have those practices set up well, please contact us or just make sure you do so, because they are high liability in case of an audit, and it's the easy picking for the government. It's very easy for the government to detect discrepancies or things that you're doing wrong in this process. Evidently, an employee does not mean independent contractor for I-9 purposes. Next slide. Okay, so because of COVID-19, you do have certain flexibilities extended through July 31st, 2023. A lot of people like you have reached out to us saying, hey, how about if we hire remote workers? How are we going to check their documents? Because they're remote, they're in another state. How am I going to look at their passport from there? So it is important to understand that not all remote work qualifies for these flexibilities, only the remote work that's due to COVID-19, right? And so you may inspect documents remotely and retain copies within 3 business days, but you do have to enter COVID-19 as a reason for physical inspection delay. If COVID-19 isn't the reason for that delay, you are not eligible to take advantage of these remote flexibilities. Employer must physically inspect documents within 3 business days once normal operations resume. Again, you have to enter COVID-19 as reason for delay and add documents physically examined with the date of inspection to Section 2 or Section 3 as appropriate. So no word on whether these flexibilities will extend beyond July 31st, 2023. So use this time to complete all the physical inspections that you haven't completed otherwise. My guess is that COVID-19 is gonna, and all the flexibility surrounding it is gonna come to an end eventually. So we all have to do this. We have to at some point inspect physically those documents. Okay. Next slide. As you know, how the I-9 verification process has list A or a choice of list B or C documents in order to verify whether someone has employment eligibility. Now, automatic proof of all of the things that is involved in employment eligibility, like ID, status, and employment authorization. There's some documents called list A documents that if you are presented with, they prove everything you need to know. They prove identity and they prove that these folks are authorized to work on US soil. So these documents are a US passport or a US passport card, a green card, an EAD, employment authorization document card, or a foreign passport with an I-94, which allows employment incident to status. And there's a few of them who do. An I-551 stamp, which is for permanent residents, L2S, spouses of L1s, E2S, spouses of E2s, and certain Afghan and Ukrainian parolees. Next slide. List B documents. So at this point, you have to combine B and C because one of these documents, you could use this document just as proof of ID, but not as proof of employment authorization. So ID can be proven via US driver's license or state photo ID, military ID, voter registration card, school or medical records for those under 18. If you see one of these documents in your mind, you should also seek a list C document next, because this is just not sufficient. Next slide, list C documents are unrestricted social security card, original or certified copy of US birth certificate, or certification of birth abroad. Next slide. All right, so now you just heard me say about the L2S and E2S visas. These are actually new categories allowing work incident to status. All that means is that these folks, if they show you an E2S visa or an L2S visa, they don't need to show you a separate EAD or employment authorization document card. And these are as new as January 30th, 2022. When USCIS and CBP began using these new classes for admission, the E1S, the E2S, the E3S, the L2S. It's a policy change that was meant to allow more flexibility to spouses of these folks so that they don't incur the additional burden of applying for work permits, which take forever these days. So that you know, a work permit has finally gotten down from 6 months down to 3 months these days, sometimes even faster, but it's just recently. Other examples of work incidental status, brand new, Ukrainian and Afghan parolees. So what used to be the case is that we brought this Ukrainian and Afghan humanitarian parole folks who were running away from wars in their country. And as soon as they landed, we made them go for an additional burden of applying for work permits instead of just letting them work incident to their status of humanitarian parole. There's been litigation, and the government has agreed to settle said litigation against them. And effective November 21st, 2022, the government has allowed Ukrainian and Afghan parolees and their qualifying family members to be employment authorized incident to status, to humanitarian parole status. So they don't need to wait for a work permit, which is terrific because these folks really need to hit the ground running and start working on as soon as possible. All right, and so these folks are, if you see the annotation OAR, those are Afghan parolees. Then UHP, those are Ukrainian parolees. And some of the Ukrainian parolees could have been admitted for DT at the border, okay? Next slide. All right, so you just heard me allude to the fact that there's been a long processing for work permits and it's finally getting down to 3 months, but it's part of a trend that we've experienced following the Trump presidency as well as the COVID crisis. The USCIS and Department of State Operations have been heavily affected. And right now, these agencies are still filling out job vacancies and training new hires, which has created said delays. So from 6 months, now I'm dealing with 3 months, so finally. And there's still long waiting times at US consulates abroad, but they're getting better. In other words, we still have to make sure any of your foreign national employees who need to process for a consulate, they plan well ahead of time and they use attorneys to do that planning. Next slide. Okay, and there's been some Department of Labor updates that intersect with the laws of employment. Equal pay transparency laws. This may affect the way we advertise for green card processes when we have to post ads. All of a sudden, we are obligated, or at least we recommend that we include salary in newspaper ads and LCA postings. We didn't have to, we used to not have to, but because from the employment side, we have these new laws, we have to adjust in the immigration realm as well. And so from now on, even whether your state mandates it or not under equal pay transparency laws, we advise employers to do it anyway, to disclose the salary in all the green card related ads, so as to avoid any violations under any state law. Technology platform. Look at your recruitment platform to make sure recruitment ads are not discriminatory. And remember the 2 safe harbor questions. So when you deal with folks that might be foreign nationals, you cannot just ask about their citizenship, nationality, paperwork status, documentation status. You are only allowed to ask 2 questions that are going to provide you a safe harbor in case of trouble, and protection against claims of discrimination based on national origin. The first question is, are you now authorized to work? And 2, will you need sponsorship to continue working for the company in the future? This is all you're allowed to ask. And the answers should be all you need to know in order to plan for employment purposes with these foreign nationals. So definitely, unless the employee voluntarily discloses possible future sponsorship, you just can't go digging, right? So you just have to wait for them to disclose it. Next slide. This is my last slide, but also my favorite one, because we are heavily involved in this program, and I wanted to signal it to you as employers of labor. And the fact that many employers are complaining of lack of labor, especially in certain sectors. Here's a source of labor: Connecticut for Ukraine Refugee Matching Program. It's our program. As a law firm, we've taken the responsibility of matching Ukrainian refugees to Connecticut sponsors on a pro bono basis in collaboration with the Honorary Consulate of Romania to Connecticut. And what we do here is we have 246 families, Ukrainian families, who want to relocate out of Ukraine, out of some European refugee camps and into Connecticut. And the way the program works, there's a new federal program that President Biden has passed in April 2022 called United for Ukraine program that allows for individual sponsorship, not company sponsorship. individual sponsorship, meaning an ordinary citizen of Connecticut could say, I want to sponsor a Ukrainian family and I'm going to facilitate, let's say, 3 months of free housing. And they fill out some minimal paperwork with the Department of Homeland Security. And less than 2 weeks later, that Ukrainian family could come and live in Connecticut and work in Connecticut. We collect data from our Ukrainian refugees so that we could figure out what their skill sets are and what their matching could be on the Connecticut market for labor. And so if companies are interested in getting labor, they should figure out a practical way to incentivize individuals, maybe employees working for the company or their communities, their church or faith communities in their area, to figure out ways for those individuals to bring the families over. And I will leave it at that. If you're still interested, you could check out the website, and there's a form that you could fill out that to sign up as a sponsor. And right now the winter is coming and Ukraine is still getting bombed. Their electricity is mostly out. People are freezing, and we've switched our efforts exclusively on plucking folks out of Ukraine because of that, and less out of European refugee camps. And so whatever we could collectively do to help, I believe it will be a win-win for not only Ukrainian refugees, but the local labor force. Thank you very much. Questions?
Okay, Dana, thank you for that update. It looks like that was a lot shorter, so you win the award than we anticipated. And it looks like we don't have any questions on the immigration update. So, so we can go ahead and sign off. I want to thank everybody for their participation. We have QR codes, very fancy, so that you can connect with us on LinkedIn. So I think the way this works is you hold your camera up to them and magic happens. So we'll keep those on the screen for a while. We have the link to our employment blog in our chat. So we invite you all to subscribe to that. And then, of course, if you have any questions for any of us on our presentations, please reach out to us directly, and we're happy to address any questions that you may have. Wishing you all a really wonderful weekend, and thank you for participating. We'll keep these QR codes up for a little bit longer before we close out, but I'm going to sign off, and thank you all for your participation.